I'd like to invite the chair of the Business Committee to advise us on our continuing program.
Thank you, Chair. Robert Hammond, Chelmsford 273. As you know, the debate on faith in the city was adjourned this morning. Bishop Rob and Mark Sheard were very grateful that we had the presentation and that we started the debate. However, as far as resuming the debate is concerned, the Business Committee has agreed not to try and squeeze it in to business in this group of sessions, but we hope to schedule the resumption of that debate in February when we meet in London. In addition, Archbishop Hosham will be with us tomorrow morning as our first item, we hope. So, understanding order 9, can I move that we insert item 14 as our first item of business tomorrow morning?
Point of order. Philip North, Blackburn 008. February 2026 is not the 40th anniversary of Faith in the City. 30% of children in this country are living under the poverty line. What does the making of this debate a contingency business, and now it's a shoddy adjournment, say about the Church's compassion for those children?
I'm afraid that's not a point of order.
Agree, vote Hosham. So the understanding order number 9, inserting item 14 as first thing tomorrow morning, a variation in business.
Does that have the Synod's consent? If so, please indicate. Green ticks on Zoom. Thank you. Those against? Red ticks on Zoom. The motion for the variation of business is carried.
Thank you.
Thank you. We come now to item 510, the abuse redress rules. In addition to the order paper 7, members will need the rules themselves, GS 2410, and the explanatory notes, GS 2410X, Part B. We'll also need the financial notice paper number 5 and the new financial notice paper 12, looking at the financial memo there as these items and amendments have financial implications. This is, in effect, part B of our debate this morning, and so the same principles, of course, apply, particularly the principles around taking care around what we say and listening well and being conscious of those who are listening in to this debate. So our procedure. First, the Dean of the Arches and Auditor will move item 510A. And this is a preliminary motion that the rules be considered. We need to do this as there are amendments to consider later on. And this debate on the preliminary motion will provide members with the opportunity to make general comments about the rules or to raise specific points, but points which do not relate to the amendments on the order paper. We'll deal with those when they come. If the preliminary motion at item 510A is carried, we'll then move to the amendments set out on the order paper. And again, members who wish to comment on an amendment shouldn't do so at item 510A, but please reserve comments for the debate on the amendment in question. And so I call the Dean of the Arches and Auditor to move item 510A, that the Abuse Redress Rules 2025 be considered. She may speak for up to 10 minutes.
Thank you, Mr. Chairman. Morag Ellis, ex officio 454. It will assist members of Synod to have to hand the draft rules, paper GS 2410, along with the explanatory notes, GS 2410X. There is a fair amount of detailed material here. In common with the chair of the steering committee, may I first of all pay tribute to the work of victims and survivors who've taken part in this process, despite the harm which they have suffered in the Church. As well as chairing the Rule Committee, I have also been a member of the Project Board. Through the contributions of the board's survivor members, I have learned much, more than they can know, and I want to thank them publicly from the bottom of my heart. As the chair of the steering committee indicated this morning, the draft rules before Synod provide part of the scheme's legislative architecture. It's unusual for Synod to be considering a measure and its rules at once, and the Rule Committee is grateful to Synod for endorsing a departure from usual practice. And the purpose behind the departure is that if Synod approves these draft rules today, then hopefully that will ensure that the scheme can commence its operation as soon as possible, subject, of course, to its parliamentary stages. I don't intend to take Synod through each rule, but wish to explain briefly how the rules are informed by the same principles as the measure itself. Where I refer to the scheme administrator, I mean Kennedy's, the specialist law firm which will administer the scheme at arm's length from the Church. Reflecting on the comments of the chair of the steering committee, I'd like to identify the elements of the rules which help to shape the person-centred approach and the generosity of intent to which he referred. Synod, you'll note in particular Rule 3, which addresses the application procedure, and there was some discussion about this morning. It allows an application to be made by a variety of means to cater for the circumstances of the particular applicant. We know that this is essential to ensure that the process starts in an accessible fashion and to reduce the inevitable pain involved in explaining what has happened. Rule 6 makes important provision to ensure that the interests of a child who applies to the scheme are properly protected. Rule 9 provides for the scheme administrator to be able to request further information. If it assesses that this information is required before an application can be fairly determined, for example, if without it a view would be reached which might be adverse to the applicant, the rules provide for an application to be treated as withdrawn, not dismissed. And the point behind that is it's to mean that a new application may be made in due course if the necessary information can be obtained. The rules expressly do not require that information must be sought in each case from the alleged perpetrator for sound policy and practical reasons. The objective of the rules involves recognising that the scheme administrator is best placed to judge what's required to make the assessment in each individual case. Rule 11 recognises that under this scheme, redress may be financial and/or bespoke. That rule introduces flexibility about the delivery of any award to meet the requirements of the applicant's circumstances, and also enshrines the requirement for an applicant to choose to accept an award, and recognises that on legal advice and after reflection, for which up to 6 months is written in, an applicant might reject and walk away from the scheme. Rule 15 is important. It provides a similar flexibility where redress is bespoke rather than financial. And the rules are intentionally non-directive about the form of non-financial redress, recognising that this will need to be discussed with each applicant case by case. Bespoke redress, we know from the Survivors Working Group, and again reiterated this morning at the Fringe meeting, is very important indeed to many survivors, and the fact that the specific provisions of the rules necessarily focus on financial matters should not obscure that important fact. Rules 16 to 21 provide an important fail-safe in the form of an appeal, and that was referred to this morning. Rule 22 adds more colour to the provision which Synod debated this morning under Special Amendment 8. It requires the Archbishop's Council to frame its assessment around relevant and objectively verifiable factors. Rule 26 makes important provision allowing for an applicant to request a pause in their application to allow some breathing space if they wish because of personal circumstances. Again, we've listened here to the working group. Rule 27 requires the scheme administrator to pause an application if it becomes aware of a current safeguarding concern or allegation. And it's important that where applications identify such matters, that they are properly addressed in accordance with the Church's safeguarding code of practice and guidance. Rule 28, which was touched on this morning as well, seeks to ensure that a lawyer may recover costs, but only up to a fixed ceiling where such a lawyer supports an application and which leads to a determination, but subject to two important conditions. First, the sum, as I've said, is fixed to ensure that a disproportionate amount of the scheme's resources are not paid in legal fees. And secondly, a lawyer would be unable to recoup their fees if they have sought to enter into any agreement with a victim or survivor which is intended to allow the firm to recover a fee of more than £5,000 plus VAT out of the redress paid. Schedule 1 is detailed and in the form of a table. It provides the mechanism for the determination of awards of financial redress. And there are 5 steps which take account of, respectively, the severity of abuse, any aggravating factors, the impact of the abuse on the applicant, and consideration of exceptional circumstances. The very final step deducts amounts which the applicant has already received in recognition of the abuse which they have suffered. The objective is one of achieving consistency and fairness, and it seeks to ensure that where a person has already received a sum of money which recognises their abuse, this should be taken into account. Otherwise, one person might receive money from several sources within the Church, for example, a civil claim through the courts, the interim support scheme, and the redress scheme, and others only one, the redress scheme. This principle is subject to an important exception for payments on account of therapeutic support. The schedule doesn't refer to bespoke redress, as I've explained. Synod, I consider that these rules are consistent with the spirit and letter of the scheme, which is non-adversarial, person-centred and compassionate, and I commend the draft rules for approval. I accordingly move item 510A. Thank you.
The preliminary motion at item 510A that the Abuse Redress Rules 2025 be considered is now open for debate. The Bishop of Dudley, followed by the Bishop of Dudley for now.
The 46 Southern Suffragan Bishops. Thank you, Chair, for calling me. I welcome the measure and these carefully worked out rules. I'm deeply grateful to all those who've worked so hard to develop what we have before us now. I want generous and timely redress for those who have suffered so grievously, often for so long. and I welcome the fact that it is people-centred and non-adversarial. I do have one just particular question, however. Under Part 2, Entitlement to Redress, Section 5, it says, the spiritual abuse by one person of another is a form of psychological or emotional abuse in a religious context, which has the effect of harming a person's spiritual well-being. That feels a very broad category to me. People sometimes say things from theological conviction in this chamber and elsewhere, all religious contexts, that may well have the effect of harming someone's spiritual well-being. Relative power and position may affect whether such comments are simply brushed off, disregarded, or cause deep and lasting hurt. So it seems an important category of abuse, spiritual abuse, but a difficult one to define. Will there be guidelines that will help people interpret a rule like that? Thank you.
I see no one else standing or otherwise indicate up. Penny Allen.
Penny Allen, Lichfield 335. I just want to speak briefly about children. There'll be a number of children who have been abused, whose abuser has now died because they are late in making their application towards this address fund. I'm really anxious that they have the opportunity to disclose and the opportunity for some redress and, if necessary, some therapy. Part of the reason I'm saying this is I have a young person that I know who has anger management issues now from his previous experience. He would not want to find himself in front of a large group of people. So I'm very glad that he can bring somebody possibly with him. He's not able to afford a lawyer in order to represent himself. In fact, he's worked his way through 7 counsellors at the moment. He is in deep distress, and he does work when he's well enough. I am anxious that he and other people in similar situations would have the opportunity to apply to this fund. What is making me anxious is what kind of support he would require if he's not able to have a lawyer. For instance, would one of his counsellors, to whom he has disclosed, be a suitable person to come with him to support him in this kind of scenario? I'm also anxious about other vulnerable adults who may feel disadvantaged in some way in able to make coherent and adequate evidence available. The young person I'm describing is dyslexic. He has certain issues which educationally have been difficult to deal with. And it's often the vulnerable in society who have experienced the abuse. And it's very important that they understand how to make a claim to this and how they need to support their evidence and who is a suitable person to bring with them. So I'm asking this on his behalf. I'm asking it on the behalf of other vulnerable adults who may be watching this and wondering how on earth, having been refused in the past some kind of advice or even the belief in their abuse, how are they going to be represented and what can we do to assist them? Thank you.
I see no one standing or indicating in the hall or on Zoom, so I call on the Dean to reply to the debate.
Thank you very much for the both contributions. I'm glad that I'm hearing welcome in principle. That is good. To answer the Bishop of Dudley's question, first of all, Clause 3.8 of the measure provides for the Archbishop's Council to produce guidance on spiritual abuse, as you have anticipated. And Penny Allen, the position of the young people that you refer to, I think that raises the essential question of whether or not people are going to be able to have legal advice and representation, and the answer is yes. This was touched on this morning. If you look at Rule 28, you will see there provisions for the payment of lawyers, but certainly legal advice and representation will be available. And if somebody wishes to be accompanied by a responsible person, such as a counsellor, and assisted through the process, that will be allowed. Perhaps it's not quite the right word, but in order as well. And in terms of people knowing of the scheme, there are already plans in train about how to communicate the existence of the scheme and of the ability to access it as widely as possible through many networks and in different forms. And you'll notice in the rules that there is provision for various ways in which an application can be made. It doesn't just have to be done in writing. Maybe people with dyslexia, for example, might find that challenging. Well, it can be done over the phone. It can be done in conversation. So we have tried to make the scheme as accessible as we possibly can. But thank you for that debate.
I now put item 510A to the vote. This will be by a show of hands. All in favour, please indicate. Green ticks on Zoom. Thank you. Those against? Red crosses. Item 510A is carried. So we now move to the amendments at items 541 to 543. Now, the 25-member procedure applies to each amendment, and that means that the mover of the amendment will have up to 5 minutes to speak to it. I will then call the Dean to speak for not more than 5 minutes in reply. If the Dean does not indicate that she wishes the debate on the amendment to continue, the amendment will lapse unless 25 members indicate that they wish the debate to continue. So I call the Reverend Geoffrey Terry to move his amendment at item 541, and he may speak for up to 5 minutes.
Geoffrey Terry, Truro 231. Thank you for calling me Chair. Synod, this amendment seeks to do two things: to fill a gap left in the rules and to provide a workable regime for seeking information from an alleged perpetrator, which both affords protection for victims who may not want any further communication with their abuser, but also ensures that no one is found to be a perpetrator without being afforded the opportunity to be heard. If I deal firstly with filling the gap, Synod, the measure itself contains no provision for the redress body to seek information from the alleged perpetrator. But Section 7, subsection 10 provides that the rules may enable the redress body to seek such information. In fact, there is at present no provision in the rules to that effect. I have consulted with Legislative Counsel and the legal team about this, and there is concern that if the rules do not now contain a provision made pursuant to section 7, subsection 10, the inference may well be drawn by anyone seeking to interpret the measure and these rules that it is the will of Synod, and therefore in due case the will of Parliament, that the redress body should not and does not have the power to seek information from an alleged perpetrator, however desirable that may be. Legislative Council has therefore expressed the view and authorised me to tell you this, that it would be prudent to make a rule under section 710, because otherwise, Synod, you may be letting the matter go by default. You must therefore tread very carefully here, Synod. There may be differences of legal opinion about this, but if you want to risk denying the redress body the ability to hear from an alleged perpetrator, by all means reject the amendment, but do so consciously and deliberately in the knowledge that you may be having that effect of denying the redress body the ability to seek information from the alleged perpetrator. And if you do think it desirable that the redress body should have a clear and fully expressed ability to seek information from the perpetrator in an appropriate case, then please vote for this amendment. And there's another powerful reason to do that. I was certainly brought up believing it's a fundamental principle of any civilized legal system that you should always hear both sides of every case. And it's imperative, I suggest, that we don't inadvertently create a system which effectively shuts out the ability of the redress body to hear both sides of every case where it's necessary or appropriate to do so. I know that we want to avoid an adversarial system, but we mustn't go so far in that direction as effectively to shut out the possibility of a perpetrator who may be innocent being heard. Remember section 7, subsection 11. In this, the redress body will be constrained by the statute such that it may only seek information from an alleged perpetrator if it has reasonable grounds to believe that making the request will help it to determine the application. By reason of the way we have constructed this measure, section 3 means that the redress body can only make an award if it is satisfied on the balance of probabilities that the alleged abuse has in fact occurred. And it can only make such a finding if it knows who the alleged perpetrator is, what their role in the church was, and what they are supposed to have done. And so making an award without hearing the perpetrator's side of the case would be tantamount to branding that person an abuser without affording that person any opportunity to defend themselves when they may in fact be perfectly innocent. And that, as I said in the debate this morning, could effectively destroy someone's life. It could take away their livelihood, their dignity. They may lose a relationship. They may even take their own lives. And so quite apart from the risk of a serious miscarriage of justice, I ask this: if the redress body has heard only one side of a case, how can it begin to weigh the probabilities of the matter, which it has to do under section 3, before it can make an award?
We've reached 5 minutes.
Synod, please vote for this amendment standing in my name, which I now move.
I call the Dean to speak in reply. She has up to 5 minutes.
Thank you very much. I'm not content for this proposed amendment to be debated for a number of reasons. The substantive reason is because of the terms of the proposed amendment. And Synod, if you have a look at it, the proposed Rule 9A, there are a number of steps involved, which include asking the applicant, if they consent, to the redress body, the administrators, approaching the perpetrator or their surviving relative, if known. That's the first point. Of course, the perpetrator may or may not, their whereabouts, their surviving relatives may or may not be known, so there is a difficulty about that. There is also in proposed paragraphs 1 and 2, it is suggested that the administrator should consult any findings by a court of competent jurisdiction that a perpetrator carried out abuse to which the application relates. Such things will often not be in the public domain. For example, county court judgments are not in the public domain. In criminal cases, yes, you'll know if there's a guilty or a not guilty verdict, but none of the details will be known, for example. So there are some real practical difficulties about this. But the really harmful, and I do say positively harmful element of this suggested amendment is paragraph 6, because if the applicant, if you've drawn a blank in hunting around for court determinations, and the applicant is then asked, is it okay for us to go to the perpetrator or their surviving relatives? At 6, if the applicant does not consent, the application is to be treated as withdrawn. And one of the things which we have heard repeatedly from the group and from the survivors on our board is that it is very, very difficult for many people, given the particular experiences which they've undergone and the lasting impact of those on their later lives, to be going to the perpetrator or knowing that somebody is going and confronting. And so we believe that in many, many instances, this will actually cause somebody's application to be deemed to be withdrawn. This is the opposite of the person-centric approach which we propose. I do want to say just a few things, if I can have a moment or two, about the arguments which the Reverend Mr. Terry has put in support of this, in particular in referring to his understanding of what has been said to him by Legislative Council. I regret to say there's clearly been some misunderstanding here. What Legislative Council has drawn Mr. Terry's attention to are the provisions in section 7 and subsections 10 and 11 of the measure, which enable rules to be made. Legislative Council has not expressed any views on policy. That would be way beyond his remit to do so, and he has very clearly been communicating that in messages sent through while Mr. Terry was speaking. So there's clearly been a misunderstanding here, but I very strongly don't wish Synod to be under any misapprehension about that. Responding to the point about the natural justice and talking about somebody being branded as a perpetrator, that was the term used. There's a very simple answer to that, and then an ever so slightly more complicated legal answer to that, and I'll give both because they're both relevant. The simple one is that these things won't be published. The slightly
I think
more
there's only time for the simple answer.
is that there will be no publication. The longer answer is Clause 8.4 of the measure expressly states that there is no determination of civil rights. Thank you.
As the Dean does not support the amendment, I have to ask whether there are 25 members who wish debate on the amendment to continue, failing which the amendment will lapse. There are not 25 members standing or otherwise indicating in the hall or on Zoom, so the amendment at 541 lapses. And so we move to the amendment at 542. I call the Venerable Paul Ayres to speak to and move item 542. He has up to 5 minutes.
As Leeds 131. Having tried to float one lead balloon this morning, I'm going to try another one. In Rule 12, paragraph 2, to leave out the subparagraph A, the rule as drafted says that an aggravating factor can be that the report of abuse was not believed by one or more church officers. And it's this word believed that pulled me up short, and I wonder if it's a mistake for several reasons. Firstly, the question is, how do you know? How can you prove it? Unless a person actually says outright, I do not believe you, how do you establish whether or not someone believes something? Believing or not believing something is a matter of the internal disposition of someone's mind, which no one else has access to. Secondly, why does it matter? The issue is not whether someone receiving a complaint believes or does not believe it, but whether they act upon it properly. So if George tells the church warden that Bill has been stealing money from his vulnerable mother, the question is not whether the church warden is inwardly disposed to believe it, but whether she then records and reports it. Conversely, the church warden might well believe it completely, but either through negligence or through fear of the consequences or for some other reason may fail to act upon it. That it would be an aggravating factor, but I don't think belief is strong enough. And thirdly, it mentions more than one church officers. So imagine George tells both church wardens and the parish safeguarding officer and the vicar, and even if one church warden says, and they definitely shouldn't, but imagine that they do, that's hard to believe, but the other church warden and the safeguarding officer and the vicar tell the skeptic it's not for us to judge, and then they all report and act correctly, 1 out of the 4 being skeptical, is that an aggravating factor? When I read that word, I was concerned that this seems to be going back to the days of the complainant must be believed. And we know that this approach was comprehensively shredded by reports into notorious safeguarding investigations in earlier years. Again, it seems like a reversal of the burden of proof. It's not the job of those receiving complaints to either believe them or disbelieve them. I know that not being believed by investigators, not taken seriously, having to go over and over again, repeating the evidence of the horrible things that have happened, having it all forensically picked over, that is terrible for victims. But that's about investigators. This is not. This is about church officers. Church officers do not, should not, and cannot investigate complaints. Their job is not to form a judgment. How could they? They have no investigative powers. Their job is to pass on the complaint to those who do have investigative powers. Whether they themselves feel it's likely or unlikely, credible or incredible, whether they're inclined to disbelieve it or believe it, is neither here nor there. They should receive reports with compassion, with care, understanding, gentleness, respect and patience. They should be very supportive to those who put them through the ordeal of reporting abuse. They absolutely shouldn't question, probe or challenge, just receive, record and report. And their role is not to pass on only complaints that they believe, but all complaints to those who can investigate it. What worries me is if this is left in the rules here, there's no doubt that it will be quoted elsewhere in other contexts. And at some point, someone will say over time, well, it says in the rules that church officers must believe complaints. I know this is only an aggravating factor once the facts of abuse have been determined, but if it were left in the rules, I just fear it would be a hostage to fortune. I know it's a detail, but we are here to check the details. We know who lives in the details, and for these reasons, I think the rules will be improved by removing this particular subparagraph. Thank you.
I call the Dean to reply. She has up to 5 minutes.
Thank you very much. No, it's not a mistake. It is an intentional use of the word, and I will briefly seek to explain why. Firstly, in many legal contexts, people are asked to draw inferences from surrounding matters and conduct. So, for example, there are many cases of historic abuse, some of which we expect and hope to be coming to make application to the scheme, before the current safeguarding procedures, which Canon Ayres was referring to, of the type of learning that we now all have, where it is clear from what didn't happen that there was disbelief. And so, for example, disclosures would be made, nothing would be done, and then sometimes with tragic consequences in terms of people being left to go on and do things again, or to go elsewhere and do really serious things elsewhere. So, and the law all over the place requires people to draw inferences, and that can be done perfectly properly from the surrounding circumstances. So it's a familiar legal concept and technique which the scheme administrator will, as experts in this area of the law, be well able to use fairly. We also know from the working group and from the survivors on the board that this is something which is received as a very aggravating factor indeed, particularly in the circumstances I outlined at the beginning, where somebody discloses, nothing happens, and then abuse happens to other people subsequently. So no, it's a deliberate use of the language, and I suggest that it is the right and appropriate use of the language here. Thank you.
The Dean has indicated that she does not support the amendment, so I need to ask whether there are 25 members who wish debate on the amendment to continue, failing which the amendment will lapse. There are 25 members standing or otherwise indicating. Now, I'm going to leave the speech limit at 5 minutes. We're doing very well at using only the time we need. We'll shorten it if we need to, given that we have timed business at 4. We're into a special area of the standing orders now in which those who have proposed amendments have a right of reply for 3 minutes at the end of this debate on the amendment. So this item 542 is now open for debate. The Bishop of Winchester, followed by Mr. Scowen.
Synod, I encourage you to resist this amendment. The poor response of the Church to disclosures of abuse is a key theme which runs throughout the sorry history of our failures in this area, and we cannot ignore that factor in our consideration of these rules. It's expressly for that reason that the scheme has been designed to recognise the fact that in some cases the Church's negative approach when faced with the disclosure of abuse has been a very significant aggravating factor, and it is aggravating factors which we are looking at here. And we have been told repeatedly by survivors that this has caused further harm to them. Now, of course, in many cases, it is unlikely that there will be any written evidence at all which records that a victim or survivor has been disbelieved. Equally, there may be no corroborative evidence of the abuse itself. But I do not see why, in principle, this should prevent the scheme administrator from considering all of the evidence and forming a view whether it was more likely than not that a person had been disbelieved, and thereby taking such action within the terms of the scheme and drawing such inferences as may be appropriate. Synod, I do urge you to resist this amendment. It's precisely this factor of being disbelieved which has been such an aggravating factor in many survivors' abusive experience of the Church. And I have to say, I do fear for those who are listening to this debate and hearing that being questioned now. Thank you.
Go in London 358. I'm going to support Mr. Ayres' amendment, despite the fact that I actually agree with a great deal of what the Dean and Bishop Philip have just said. I entirely accept that it is an aggravating factor when somebody has reported abuse and the person to whom they report it say, "I don't believe you, go away, he wouldn't do that." That has happened many times, and I can quite see, not myself being a victim, but I can quite see that it would be an enormously aggravating factor for that to happen. The difficulty is with the word believed. There are other ways of expressing everything that Bishop Philip and the Dean want to say, which would make it clear that what we're talking about is active rejection of a complaint or a decision not to investigate because of a rejection of that complaint, that does not give the impression that it is the duty of a church officer to believe, rather than, as Mr. Ayres has pointed out, to listen, to record, and to ensure investigation. That's what people should be doing. It's what people should always have done. And to suggest now that we should go back to a situation where a church officer is under a duty, because that's the inference, to believe everything they're told rather than simply to record it and act on it, I think is a very retrograde step. So what I'm suggesting is that we pass Mr. Ayres' amendment, but invite the Royal Committee to bring back in February a new form of words to replace the concept, which is a right one, but far more clearly and less ambiguously expressed. It's going to be some months before the measure that we've just approved actually becomes law. Probably not before February, we shall see. So we have time to revisit this matter at the next group of sessions and put in a much better form of words, and that's why I support Mr. Ayres' amendment.
The Chair of the House of Laity, followed by the Prolocutor of York.
Jamie Harrison Durham, 301, a member of the Archbishop's Council and also the board for Redress. One of the things we do here is to send messages either overtly or subliminally about what we're doing. And I think there's a whole area here about what's symbolic here and what's the message we're given. Much of what I was going to say, Bishop Philip has said, so I'm going to move slightly to one side to ask that question. And also, often when we come to a debate or an agenda, we might say, well, whose eyes are we trying to see this piece of work through? Is it our own eyes? Is it the eyes of our neighbour? Or in this case, is it the eyes of our survivors and victims? And how are they seeing what we're doing and saying? The other thing is, and as a layperson I can talk theology, is that what we believe is no good unless that belief is worked out in practice. In other words, by believing, we show in reality that that belief is actually correct and true. And the message we've heard, as Philip says, over the years, 30, 40 years for some, is they've kept coming back to someone saying, this happened, and they're not believed. And the effect, therefore, is nothing happens. Oh, yes, we could say it was about, well, they didn't act. And of course, all our later guidance is very clear about the importance of action. But in these contexts, belief, to me, is quite fundamental. So I do think paragraph 6 also, sorry, I'm going off piste. I think the whole issue of where we're going with this is very much through that lens. What is the message we're sending? The other thing is we have a hugely experienced team who are going to work for us as the scheme administrators, Kennedy's. It's an international law firm, and it was particularly noted for its work on the Lambeth scheme, the Lambeth Redress scheme. And I think victims and survivors have seen that, and in their graciousness and their kindness have said, yes, we can see why you've chosen them, and I hope they were involved in that process. So we have some confidence that this very able international firm will work out what this would work out in practice. What does it mean? What to say there was belief or not to believe? So I do ask you to reject this amendment and show that that's the symbolic response we want. Not only is it true, theologically and practically, but we can have confidence in the company that we've asked to do the work for us.
Kate Walton, Liverpool 157. I want to agree very strongly with the Dean of the Arches and to echo all that Bishop Philip has said and to urge Synod to vote against this amendment. I am glad that the word believe appears in this rule. In all of our safeguarding training, we are encouraged always to believe anyone who discloses abuse. This is our role, our duty, as those who hear disclosures. We owe that to those who share their stories with us at great cost. Not to be believed is a dreadful, painful thing. To be believed is a cherished gift. Paul suggests that someone could not believe and still act, or believe but not act, but I think that's to miss the point. The officer is to believe, and they are to act. It is for others down the line to make further decisions. We have heard how important this is to survivors. We must listen. For too long we have got this wrong. Let us not do so again in this clause.
Anna de Castro, followed by Neil Robbie.
Anna de Castro, 408 Sheffield. I just wanted to slightly push back a little bit on the last two speeches, because I feel they're slightly missing the point of the amendment. I was a parish safeguarding officer for 8 years in a very high needs parish, and I work and liaise with our safeguarding team in the Currish parish that I serve in. Whenever a disclosure is made, it's not my job to pass judgment upon that disclosure. One way or another, my job in that moment is to be very grateful and supportive of that person who has made that disclosure, to treat them with kindness and dignity and respect, and to thank them for doing so, to record as accurately as I can and ensure I've heard that disclosure properly, and then to pass that on, that information on to the DSO or the DSA. And so I do think language is really important, and I do understand the speeches from those, the heart and the principle of the speeches that we've heard of those who are wanting to resist this amendment. But I just think that it slightly edges over into a job that just really isn't ours. So the principle is to treat people with gratitude for coming, and courtesy and respect and gladness, and to do our duty and job to support and care for that individual. But to kind of to remove this and change this language of believe isn't to say, I don't believe you until you're proven right. That's not at all what the amendment does. And so I just want to kind of push a little bit against those last two speeches that we've heard, because I think they slightly miss the point. Thank you.
Neil Robbie, Lichfield 143. Thank you, Chair, for calling me. I said in my election address for Synod that I would represent the neurodiverse community in the church, and I am dyslexic and I find processing words hard. I've already heard three different definitions of the word believe in the last few addresses or in this debate, and I experience quite a lot of discombobulation when people start discussing what a word actually means. I need real clarity. And therefore, for the sake of those who may be victims, I understand that the legal side, the Kennedys of this world, or there are other law firms available, we know that, the legal definition of the word believe, or how we understand it as those who are processing the legislation, is one thing, but I think the believers need to be the word belief needs to be understood also from the victim's point of view, who might use it in a different way, and then argue that they're not being heard again because the lawyers aren't believing them. I therefore support the amendment, if not in the clause itself, then at least in the glossary.
I'm going to take two more contributions, one from the Bishop of Stepney and one from Carolyn Graham on Zoom. And then I'll test the mind of Synod.
Thank you. Joanne Granfell, 048, Southern Suffragans and Lead Bishop for Safeguarding. I do wonder if we're getting, for good reasons, slightly confused, as I think perhaps we were occasionally this morning. We're not debating managing allegations or responding well. We're not passing judgment on a good parish safeguarding officer's best attempts, but sometimes modelled ways of responding. What we're trying to do is look at whether the lack of belief and the lack of action as if we believe a victim is an aggravating factor when we're looking at redress. Those are separate issues. So it's not that it's wrong to split hairs about definitions. I like a good definition as well as anybody else. But my suggestion is that here we're splitting the wrong hair. Let's concentrate on redress. Thank you.
Carolyn Graham on Zoom.
Sorry, Carolyn Graham, Guildford 319. I think the problem is that these are legal rules written in legal language. And
Carolyn, Carolyn, could you put your video on, please, if you're able to do so?
I have put it on twice. Is it on now?
No, but we'll simply listen to you.
Sorry, I can see myself, but obviously I can't see you. I mean, I can see you too. The problem is this is legal rules using legal language. I speak as a solicitor. I now work in a judicial capacity. It's normal in legal terms to talk about what somebody knew or believed, perhaps. And so this belief it's not a question of looking into somebody's heads and working out what they were thinking at the time. It's looking at what happened on the balance of possibilities and then deciding from what happened what somebody must have believed at the time. But as we've said, it's not about deciding whether they're guilty or not here. It's deciding whether the person suffered extra harm when deciding whether or not, or how much recompense to give them. If what happened gives the impression that they weren't believed because nothing was done, then that is obviously makes things worse, made what they suffered worse than otherwise. And that's why you use this language, but it's legal language, and people shouldn't worry too much about it. It is good language to use in legal rules. So thank you. Please resist the amendment.
I'd like to test the mind of Synod as to whether item 542 has been sufficiently debated. All those in favour of the closure on this item, please show. Thank you, green ticks. Those opposed, red crosses. The motion for closure is carried. So I invite Archdeacon Ayres, as the mover of the amendment, to speak and reply for not more than 3 minutes.
Paul Ayres, Leeds 131. I think the debate has been very helpful, and I think it illustrates exactly the point I'm trying to make, that there's this confusion between, and people keep on muddling up the difference between believing something in your head and acting upon it, which is the crucial thing. I think it's an entirely legitimate question to ask, and I don't think it's fair to imply that by doing so we're somehow casting doubt on the words of victims. Really grateful for Clive's support. I agree, it's the word believe. It's the active rejection of a complaint that is an aggravating factor, and we shouldn't put church officers under a duty to believe everything that they are told. To Jamie, I'd say I'm also trying to see it through the eyes of church officers, and we've just defined them extremely widely. We're not talking about the perpetrators, we're talking about people in a difficult position receiving a report and trying to understand what to do with it. I have to disagree with the prolocutor. I think it's quite wrong to say that our safeguarding training tells us to believe what we're told. It's just not the case. Listening is not the same as believing. And church officers, I agree with Anna de Castro, church officers, it's not their job to judge, but to receive, record and report. I'll leave it to the decision of Synod.
I now put item 542 to the vote. This will be by show of hands, green ticks on Zoom. All in favour of the amendment, please show. Green ticks. Those opposed to the amendment, please show. Red crosses. The amendment is lost. We move to item 543. And I call on the Bishop of Birkenhead to move the amendment at item 543. She has up to 5 minutes.
Thank you, Chair. Julie Connelty, 51, Northern Suffragans. Declarations of interest, former Deputy Lead Bishop for Safeguarding. Somebody told me yesterday that's quite a dangerous thing. Former panel member of the Interim Support Scheme and current Church of England Trustee of Safe Spaces England and Wales. As the redress rules are currently written, any support payments made to a survivor or victim through the Interim Support Scheme, known as the ISS, will be deducted from their financial redress award, excepting money used for therapeutic purposes. This could potentially impact 125 applicants, and the total amount recoverable from them would be under 2 million if you take off those therapy costs. The purpose of this amendment is to try to ensure that no support payments made through the ISS can be deducted from redress. This is not in any way intended to put a spanner in the works of the redress scheme. I was one of those calling for just such an initiative way back at Synod in February 2020, believe it or not. And I'm hugely grateful to Bishop Philip and the project board and everybody else who's worked so hard to get us to where we are today. Survivors have different views about the equity of my proposal. Some feel that they would have applied to the ISS had they known it would not be deducted from redress, and that it's unfair that some people get more money than others. But the ISS was open to all survivors and victims who had immediate and urgent needs. Support was given according to individual need and not in proportion or relation to harm done. Meanwhile, other survivors who received payments from the ISS in the early stages were completely unaware back then that their support payments could impact their redress awards. So there's no perfect solution. But if we go back to first principles, it's important to note that the two schemes have never really been linked and are fundamentally different. The terms of reference for the ISS state that the focus of the ISS is urgent distress, and it is not intended to provide restitution, redress, or compensation. So comparing the two schemes is like comparing apples and oranges. Some recipients of ISS support may not even be eligible for redress, and some may never apply. Nonetheless, I do anticipate that a significant number of the 125 ISS recipients will also, in time, be awarded financial redress, amongst other forms of redress. Let's not forget about those. And that brings me really to my major concern. Imagine being told that the financial redress payment due to you is 50k, but that because you had a crisis a couple of years ago and received ISS support payments, your redress is slashed to 20k or 10k or nothing. I believe there's significant risk of applicants feeling their life has been devalued if this happens, and the cost of harm done to them been discounted. This will add to their distress and also undermine the efficacy of the redress scheme. It will feel like penny pinching and not convey the penitence and contrition that we intend. Moreover, for those victims and survivors who've already experienced a process whereby insurance payouts were slashed following desktop psychological assessments, something they've all described as abusive, this feels like a repeated pattern, albeit for a different reason, and it could be massively triggering. On balance, I therefore contend that by passing this amendment to the redress rules, we'll give the redress scheme a cleaner and better start, not mired in contention and disappointment, and will reduce the risk of re-traumatisation. There's no perfectly fair way forward, but I believe my proposal reduces the risk of harm. I often reflect on God's immeasurable, ridiculous generosity with us, and yet the Church is so often experienced by survivors as mean-spirited and even cruel. Synod, please let's have a debate on my amendment, and I urge you to support it. I believe it will make the redress scheme operate more in line with the economy of the kingdom of God.
Thank you. I call the Dean to speak in reply. She has up to 5 minutes.
I'm going to buy back some time, Chair. I consider that it's important that the mind of Synod is heard on this question, and for that reason I confirm that I'm content for Synod to debate it.
As the Dean is content for item 543 to be debated, the item is now open for debate. James Carey, followed by, yes, you, madam, yeah, in the stripy shirt.
James Carey, 246, Bath and Wells, also a member of the Archbishop's Council and former member of the Redress Scheme Board, and also overseeing some of the interim support scheme. And I thank Bishop Julie very much, not only for her work with victims and survivors and on the Redress Scheme Board and many other ways, but also the honesty with which she has put forward her amendment by saying there is no perfect solution. And we often find ourselves saying in these matters, we are where we are. And so I really appreciate the way she has put her case. Earlier in Synod, we talked about how we rubber stamp. There's no rubber stamping here, no rubber stamp is available. If you would like a large rubber stamp, I'm afraid you're out of luck. You're really going to have to think about this one very carefully. I was aware of a little bit of background. There is a helpful order paper, a 12th notice paper, which gives you a bit more information about the interim support scheme and some numbers there. And of course, numbers don't always tell the full story. But just a little bit of background that the interim support scheme began in 2020. It was not a good year in many ways because the Archbishop's Council were meeting on Zoom because it was locked down. But this is something we felt we had to do, and we did it at speed. And therefore, the terms of reference changed and evolved over time. This is before the ICSA report had finally been published in its full form, and this is also before the redress scheme began. So there's a sense in which earlier applicants to this scheme, of course, knew nothing about what the implications of it would be, and therefore we have to acknowledge that. But I would also like to be clear that from relatively early on, when it was quite clear that this would be an issue, we did make it clear to those who applied to the scheme that some financial award would be taken into consideration with regard to a claim to the redress scheme. And again, just to be clear, the amount of money may seem very large to some or very small, but also the applicants themselves vary wildly in terms of the claims that they've had to make due to cope with their urgent and immediate needs. Over half of those who claimed under the ISS have claimed less than £5,000, and in fact, that group, the average claim has been about £2,000, very small amounts of money for lots of people. Much of the claim, as Julie has mentioned, was for therapeutic purposes, much of which is not available on the NHS, particularly in the volume that was required, but also in terms of the level of expertise and the specificity required of the counselling, which the ISS was happy to fund. And so therefore we're left with a situation where we have to honour all these different competing things in which, as Archbishop's Council members, we have to think about how we spend the money of the Council with regard to our charitable aims. But actually, as Bishop Bishop Philip Mount Stephen said this morning, it's not about money. It's not about money, it's doing the right thing. And actually, this is also about honouring those who have not claimed on the ISS because they have been led to believe rightly, and this has been the plan up until now, that this would be deducted. And so it's a question for me of equity, which is why I will be voting against this amendment, and I want to give people permission to do that, and there is a case for doing that. But unfortunately, there's no rubber stamp here. You will have to make up your own mind, and I hope this debate will help us to do that well together, Synod. Thank you very much.
Jane Rosen, Rochester, 389. Now, Synod, yesterday in the BBC News, there was a case of a woman, a 92-year-old post office scandal survivor, and she has only been offered 70% of her compensation claim. Now, the reaction across social media to this has been one of outrage and shock that she should have been treated in what was seen as a shabby and mean way. Yesterday in the Minster, I listened to the powerful words of Archbishop Chang. He reminded us of Jesus' command to go and do likewise. And he was, of course, referencing the Good Samaritan, who did not walk by someone in distress and pain. Instead, he bandaged their wounds, having already poured oil and wine on them. He then paid 2 denarii for immediate care, with the promise of more to come, if necessary. This was not a one-stop fix, but what was given was what was needed and what was necessary. And Synod, I say we need to go and do likewise here, in this instance. We need to be kind and generous, showing a real generosity of spirit to those who have been wounded and hurt whilst in our care. And for those for whom simply many have just walked them by. So let us now not further trample over them,
but give generously and freely so that they may feel loving kindness, they may feel valued, and they may heal well. We need to go and do likewise, knowing exactly what Jesus would do, and so what he would wish us to do. We have not always got this right, but now we have both the resources and the ability to make this happen. Please, Synod, let us be that Good Samaritan and support this amendment.
The Archbishop of York, followed by Jenny Bridgman.
Stephen Cottrell, York 002. Dear friends, like Bishop Julie, I too feel a bit torn about how best to discern this one, but there are three reasons why I am going to urge you, Synod, if your conscience allows it, to support what Bishop Julie is saying to us, and I thank her for that, and also thank her for her very persistent witness on behalf of victims and survivors. And also, today could be such an important day in the life of our church, and I don't want us to give an uncertain sound in any way. So these are my three reasons for supporting this amendment. First of all, philosophically, interim support and redress are not the same thing. The very names indicate that, and by wrapping them up, or appearing to wrap them up, I feel we may give an uncertain sound. Secondly, trust. We talk about trust so much in this synod, and goodness knows I understand why. But in the end, trust is something we choose to give or choose to withhold. And more than anything else, this redress scheme will work because victims and survivors trust it. And I believe if we did anything which may cause them to not trust it, could be so disastrous. So I speak now to victims and survivors in the room or who are watching. This scheme exists because of our manifold failures, which we acknowledge and of which we repent, and of which we heard much about this morning. The redress scheme is just one part of what we must do to build a better and a different future and to acknowledge the failings of the past. But I want you to trust it, and also I want you to know that we trust you, that you will come to the redress scheme honestly and appropriately and bring what you need to bring. But thirdly, because of those manifold failures, which are the reason this scheme exists, Synod, why not be generous?
Jenny Bridgman, Chester 88. I'm speaking in favour of this amendment. Last night I read the story of Amy Bradford, an American artist who followed civil proceedings to sue the man who raped her after prosecution was denied. She sued him for the sum of $30, which she requested to be donated to a rape crisis centre. For Amy, this amount was symbolic. It represented the betrayal she had experienced, not just at the hands of her attacker, but at wider society. Taking just $30 from a wealthy man was, for Amy, a purely symbolic act of restitution, the price of betrayal, not without theological undertones. Amy's story is told by psychiatrist Judith Herman. I've drawn on Herman's work before in this chamber, arguing for a deeper awareness among us of the stages of healing after abuse, safety, acknowledgement, and reconnection. Herman has since developed her work and added a fourth stage of healing, that of justice. Justice achieved through apology and restitution, mediated not by the perpetrator, but through a community. A shared ownership of responsibility for failure and a shared responsibility to put that right. Today we move one step closer to justice. It's been said already today, we cannot put a price on restitution. No amount of money can be sufficient to mend the harm caused to those abused by the Church and its officers. The redress we offer, both financial redress and other remedies, is always, at least in part, a symbolic act of restitution. And this symbolic act must be marked by an overflowing of abundant generosity, in penitence and in sorrow, for the reality stated time and again from the floor and from the platform here, that to this point we have not done all we could or should have done. Without this amendment, we risk a symbolic taking away. Yes, we may save a bit of cash, but what we will also do is undermine the whole spirit of this scheme. We will lose the trust of those for whom it will take such courage to return for justice to the institution which harmed them. We will risk re-traumatising those who have waited so long and received so little. Today we take a step towards justice. Please don't allow this to be compromised or soured by what would be perceived as a symbolic taking away. Vote in favour of this amendment.
I'm going to call Martin Sewell, followed by the Bishop of Rochester, and then test the mind of Synod.
Thank you, Chair. Martin Sewell, 390 Rochester. I was one of those who helped to put this scheme to initiate this scheme, and one of the things I was passionate about was that it had to be in two phases. The interim scheme was always intended to be discretionary, and the redress scheme was right. You either had a right to this, but in the interim, because it was going to take a long time, we had to have a fund that looked after people in the meantime. It has taken a very long time to get here, and I've just received a message from one of my survivor contacts. My continued interim payments for therapy are for damages engaged in the interim process. He's just been waiting so long, it's just multiplied and multiplied. He should have had his redress ages ago, but we couldn't get our act together. That's not out. I get that it's taken a long time, but you need to understand the principle here. There's a discretionary, generous scheme, and I don't want us to claw that back. That would be unjust. But there's a very serious point as well, that I have been part, occasionally, of a suicide watch on a victim. And if you claw back what he's already had, he will have nothing, and he may go over the edge. And how will that look for us? I really ask you to take that very, very seriously. When we put this scheme together, I understand that the interim scheme had 10 million hypothecated against it. As you hear, the victims didn't rush to grab the money. Most of them don't care about the money. They want the symbolism that we've just heard about. I think we spent some 2 million, so we're already 8 million to the good. Just remember that. We don't want people to be cut off and fall over the cliff. Julie, who was also part of that early push to get this thing through, she knows what she's speaking about. Please support her amendment.
Before the Bishop of Rochester speaks, could I just check whether there's anyone who wishes to speak against the amendment? Okay, thank you. Bishop of Rochester and then Carl, please.
Jonathan Gibbs, Rochester 33. I declare an interest as the former lead bishop, and I'll do my best to get through this because it touches some very deep things in me, as in many others. Back in 2020, there was nothing. There was no scheme. the Archbishop of Canterbury gave us £10,000 to meet an immediate need where someone was at the risk of suicide. The Archbishop's Council, their first meeting afterwards, responded creatively, making an initial grant of £250,000. We were hand to mouth. We were making it up as we went along. It was messy. But the interim support scheme was never about redress. It was about providing people with necessary and immediate support in urgent circumstances, pending the establishment of the redress scheme. Now, of course, things were tidied up and went along, and I recognise, there are conflicting views because terms of reference were put in place and all the rest of it. But please understand, that's why it was called the interim support scheme. It was to put an emergency support measure in place prior to our setting up the redress scheme, which has taken longer than any of us would have hoped. It was about emergency assistance for urgent need, not about a permanent redress settlement. I know there's some issues of fairness potentially in this. It is messy, but it's not Lord tell a parable sometime about workers in the field and how much they were paid. Fairness doesn't always quite work out so neatly. No, I do urge Synod here, please, to avoid re-traumatising survivors. I urge Synod at this point to err on the side of generosity. We are finally about to get our redress scheme up and running 5 years after. Please understand that if this amendment is not passed, the impact will be the greatest on some of those victims and survivors who've suffered the most and the longest in all of this. So it's messy, it was messy, but let's err on the side of generosity, and I believe with the heart of our Lord in the midst of this. Thank you.
Thank you, Chair. Carl Hughes, 467 Archbishop's Council. I am concerned that Synod is picking on one particular aspect of the redress scheme without fully considering unintended consequences. And I appreciate the desire for us to be generous. And that desire underpins and underlies the whole redress scheme. It's a very generous scheme. However, as James Carey has said, this for me is a matter of equity. This is not about saving money, this is a matter of equity. And I believe that the ISS payment should remain subject to offsetting for several reasons. First of all, Synod has already agreed in principle that previous compensation should be considered for equitable treatment. Secondly, excluding the ISS would create inequity amongst eligible applicants. The offsetting aims to prevent double counting for the same harm from different sources. And without offsetting, those who received substantial ISS awards could gain significantly more than other survivors. And the current rules maintain a single coherent assessment mode for all prior compensation. So I do urge Synod to resist this amendment. Thank you.
I'd like to test the mind of Synod as to whether item 543 has been sufficiently debated. Those in favour of the motion for closure, please show. Green ticks. Thank you. Those against, red crosses. The motion for closure is carried. The Bishop of Birkenhead may reply. She has up to 3 minutes.
I won't take all 3, but just want to say thank you. I'm still the Bishop of Birkenhead, by the way, 51, if you needed to know that again. Thank you to, that's exactly the sort of debate I wanted. So thank you that we got the broad sets of views. I really want Synod to make a clear decision, well informed here. So thank you for that. Thank you to all those people who reminded us about generosity. Somebody said to me earlier today that the Good Samaritan didn't nip back and ask the innkeeper for a refund. And I thought that was a rather nice riff on the Good Samaritan story that might be applied. This isn't about the money. This is about getting this scheme off to the best start. It's about avoiding harm and re-traumatisation. the interim support scheme was never compensation. I urge you to vote for my amendment. Do I need to move it?
You've already moved it.
Oh, great. Marvellous. Thank you very much.
I now put the amendment at item 5. Point of order.
Thank you, Chair. John Wilson, Lichfield 341. Given that there are a great interest in this outside of this chamber, it's important that we have an accurate tally of who votes which way. So understanding order 37.3, if you would order a count of the synod.
I'd like to test the mind of the synod as to whether it would like to do that. Do 25 members wish a counted vote to take place? Yes, 25 members do. Do I need? Okay. Okay. Thank you. I'm going to dispense with the ringing of the bell. This is a counted vote of the whole synod on item 543. Those present in Central Hall using the voting handsets and who wish to vote in favor should press 1. Those against should press 2. Those who wish to record an abstention should press 3. Those participating remotely should use the online voting platform and vote or register an abstention using the buttons on the screen.
The voting period is now open and will end in 1 minute. The voting period will end in 15 seconds. The voting period has now ended.
They're voted on item 543. In favor 237, against 32, recorded abstentions 12. Item 543 was therefore carried. We now move to item 510B, and I call the Dean of the Arches and Auditor to move that item 510B, that the Abuse Redress Rules 2025 as amended be approved. And to speak, she has up to 10 minutes.
Morag Ellis, 454, ex officio. Thank you for this chance. I shall take a moment or two really to thank members of Synod for the good debate that we've had, for the good and thoughtful points which have been raised, and to all who have contributed, and the way in which, the tone in which this has been done. Finally, however, I wish to reiterate my thanks to the Survivors Working Group and the board members, the Survivor board members, who have been so instrumental in getting us to this point. And I move that the Abuse Redress Rules 2025 be approved. Thank you.
Synod, we have timed business no later than 4 o'clock. If we are to finish this item before 4, it's entirely in our hands as to how much further we believe this item needs to be debated. So the speech limit remains at 5 minutes, unless we need to reduce it. But that is up to us as to how much we want to use that or not. So item 510B, as amended by item 543, is now open for debate. Yes. Yes, Neil and Burgess, and yes, indeed.
I know Neil Burgess and I, Nick Land, are like twins.
Nick Land, I know.
But I'm just 100% bigger than Neil is. It's Nick Land, York 437. I did submit, when this was under review, some cautions about the process of moving from determining that abuse had occurred and the quantum in terms of how that was recognised. And I absolutely fully support the process that we have here and the necessity for those who have been abused not to have to confront or be involved with their abuser. But the concern I had was the process that then went under 17, that there might be a request to other organisations to contribute that. Because it did seem to me that that process, whereas it says a determination has been made that somebody has been the abuser, that it would be very difficult to maintain confidentiality. If you go to a PCC and say, well, your last vicar but one has been determined to have committed this abuse, and this has been in no way previously in the public domain and has not been determined in any other place, then the resulted destruction would be significant. And it did seem to me that there needed to be some rules. It does say may, but there needed to be some rules about that process of what would be thought about before, yes, you determine that someone has been abused, you determine the quantum of their compensation, and that's right and proper. But before you go to a step where you're bringing into the public domain that you have determined that X has been the abuser, then I do think we see some clarity on that. I've worked extensively both with abusers and with those who've been abused, and I've certainly come across many people who have been genuinely and seriously abused, but as a child or as a vulnerable adult, they've been perhaps clear about where they've been abused, but they have not been clear about who the abuser has been, or they have been mistaken. Now, they should still be compensated. They have still been abused. I don't want to deny them the redress they deserve, but we just need to be really careful about moving from that point to we will now try and recall the costs from somewhere else. Final point to make. The evidence is that when you're accused at that point, of having committed abuse, you've not had any opportunity to talk about it, the suicide rate is extremely high. And we're going on balance of probabilities. And therefore, sometimes mistakes will have been made about that identity. I just think, although I fully accept, I'm not wanting to delay this, but I just think we are going to need to think, as we instruct those people doing this work on our behalf, that actually there should be a really serious determination and thinking about it before we move from the point of having determined the quantum to seeing if we can secure funding from other places. Thank you very much.
Lucy Doherty, Portsmouth 385. Thank you for calling me, Chair. I just wanted to make an observation which I felt, having listened to this debate both this morning and this afternoon. It's not about anything technical, far be it from me to do that. But I just wanted to say that it's not very often I feel really proud of General Synod, but I do today. It's taken 5 years to get to where we've got. 5 very painful years during which we've had to examine ourselves more than once and what we've been trying to do. But we've done that in public every time. And I couldn't help contrasting the way we've got to today, with what's happened in the public with the post office scandal and the scandal to do with the blood, I can't think of the right word, sorry. And the optics that has presented to the general public, for whom I'm sure they have not been able to understand why it has taken so long for redress to be sorted out for those very deserving groups of people. So I'm not trying to say, oh, aren't we wonderful or whatever. I'm just trying to say that, especially in light of what Archbishop Chang said yesterday, go and do likewise. I feel we've actually lived up to what Jesus has asked us to do. At long last, we have gone and done likewise, and as a result of the amendments we've made today, we've achieved that. And I think we should be able to say to our parishes when we get back home, we have, at last, we hope, at last, set the record straight. It's not over yet, I know, but we've set the record straight and we're on a new road. And I just wish that those in public government and whatever they are could do likewise for other people who are suffering. Thank you.
Lisa Batty.
Lisa Batty, Manchester 169. Thank you very much for calling me. I would just like us to please, while we are celebrating something really good, to include the people for whom this may traumatise them again. And I'm speaking about the hundreds of clergy who've been through the now discredited clergy disciplinary measure. We do not have the CCM yet in place, and there will be many of them who are now worried that their accusers from vexatious or vindictive complaints will now be making application for redress. This is likely to increase their PTSD. I have in the past asked if those for whom they felt the severest moral injury in connection with the church being effectively abusive towards them because the CGM was defective, if their need could be be brought forward for redress. And I have been assured that if they meet the conditions, they too can claim back those thousands of pounds that some of them have paid on defending themselves against these strange and weird complaints. And please, there are some people who do make a business out of complaining about people and authority. So, can we include that this is not about those who've been through that process? It's about those who have needed this for so long. And can we celebrate that all people who have been harmed in some way by our church are now capable of claiming, or at least applying for, forms of redress that they need? Thank you.
I see no one indicating or standing So I call on the Dean to reply. She has up to 5 minutes.
Morag Ellis 454. Nick Land, thank you very much for your engagement with the process and for your contribution today. Just a couple of answers to that. Firstly, I do want to reiterate that claims and awards under the scheme will not be in the public domain. That's the first point. But then in answer to your full point that you were making, yes, in working with the scheme administrators, clearly they will be asked to exercise great care and circumspection before and during the course of making approaches to appropriate authorities, as you suggest. Thank you. Lucy Doherty, in terms of our own conduct, as it were, I think really all I would like to do is, again, to thank those who have worked with the Church to bring us to this point today, from amongst the victim and survivor groups and communities. And Ms. Batty, I'm sorry, I didn't catch your Christian name. Just to clarify, the scope of the scheme and therefore the scope and power of rulemaking is defined by section 3.5 of the measure which was approved this morning. That is the subsection which defines the various sorts of abuse. So that is what this redress scheme is about, for clarity. Synod, as I said earlier, we've had a good and I believe, I hope, sensitive discussion today. I think I am sensing general support for these rules as the necessary companion to the measure, and I therefore move that they be approved. Thank you very much.
I now put item 510B as amended by item 543 to the vote. This will be by show of hands or green ticks. All those in favour of item 510B? Thank you. Those against, red crosses. The item is carried. We move now to the next item, the Archbishop's Council budget.
We come now to items 21 and 22 on the agenda, the debate on the Archbishop's Council budget and proposals for apportionment. For these items, members will need GS 2411, and because they have financial impact, your attention is drawn to notice paper 5, the financial memorandum. We will debate and vote on items 21 and 22 consecutively. Members will want to note that these two items are followed by timed business at 5:15. As always, we will want to use the time available wisely. I call upon Carl Hughes to speak to items 21 and 22, and then to move item 21. As Carl will speak to both items now, thereby saving time when we come to item 22, in the exercise of my discretion under Standing Order 22.3, Carl will have up to 12 minutes.
Thank you, Chairman. Can you hear me? Thank you, Chairman. Carl Hughes, 467 Archbishop's Council. Synod, you will be delighted to know that this item represents the last time that you'll be hearing from me in this group of sessions. And I also note that you don't very often have the opportunity to hear at length from two Carls on the same day. I'm genuinely pleased to present the Archbishop's Council's 2026 budget, which, as I explained on Friday, covers all of the Council's planned activity, rather than just the expenditure to which the 5 apportionment votes contributed. The budget before you therefore totals £308 million, rather than the £64 million that Synod reviewed last year. For efficiency, you have just 2 motions before you today, rather than the 7 that I had to move last year. On a comparable basis, budgeted expenditure in 2026 is almost a quarter more than the forecast for this current year. Forecast expenditure in the next triennium is a third more than the current triennium. And this is broadly evenly split between inflationary growth and real growth in support of the work and mission of our church. We should always remember that most funding for our churches comes from generous giving within our parishes and communities. The Council's budget represents only around 1/9 of the total Church of England income and expenditure. And we must be thankful to God for the blessings he has given us, including the national and diocesan resources, and the continued commitment and generosity of many people across the country, individuals giving to parishes, and parishes giving to dioceses. You've already heard this weekend about many of the key elements of the budget, which is largely an outworking of the triennium spending plans insofar as they relate to the Council. The headline summaries of the 2026 budget is on the next slide. Firstly, funding to support the work of parishes, other worshipping communities, and those who minister in them, the heart of everything we do as a church. Funding to train ministers, and from autumn next year, this will be simplified through the new ministry training fund arrangements. The Council will administer ordinand maintenance grants as well as training fees paid to TEIs. Next, new funding to improve housing choice for clergy in retirement through investing in new products and services in addition to support for the existing clergy retirement housing scheme. Next, funding for our national safeguarding team and the work on future safeguarding structures. Next, funding to continue work on buildings for mission, net zero carbon, and social and racial justice. And finally, funding for the Council's core costs not included in the above funding streams. This is largely the cost of staff teams to help the Council deliver its responsibilities and priorities, including the work that this Synod asks us to do. We look to do work that is best carried out at a national level, or work which is done more efficiently and effectively nationally. This includes providing resources for parishes, such as the Church Support Hub, the Parish Giving Scheme, and a Church Near You website. I encourage you to visit the stand in the Exhibition Centre to find out more about these. Core costs also include the Church of England's financial commitment to the Anglican Communion budget, various ecumenical organisations, and the Church Urban Fund. In the time available to me, I would like to highlight three areas. Firstly, safeguarding. We have spent much of today on the redress scheme, and you will recall that the Commissioners have made £150 million available towards its costs. This sum is included in the spending plans, but given the uncertainty over the timing of the scheme launch and the timing and size of financial redress payments, we have not included any figures for the scheme in the 2026 budget. This is pragmatic, as it will not be meaningful to report on inevitable variances against budget at this early stage, but we will obviously revisit this approach once the scheme is open. I assure the Synod that the Council remains firmly committed to delivering the redress scheme for survivors on behalf of the Church and to report regularly on outcomes once the scheme becomes operational. The budget includes provision for the work of the National Safeguarding Team and on safeguarding structures following the decisions taken by the Synod in February. An update on this work is in GS MISC 1417. We will continue to update the Synod on progress of the work, including the two major work streams on scrutiny and operational delivery. The budget includes significant support for frontline mission and ministry through several integrated funding schemes, through which the Archbishop's Council partners with dioceses. Funding for the lowest income communities will be increased by 30% in real terms, with an additional £10 million per year available to support mission in our most deprived contexts, meaning that link funding for 2026 is £42.8 million. Funding continues to be available through the Diocesan Investment Programme to enable the vision and strategy to be realised in our parishes and working communities in a way appropriate to the local context. This funding supports dioceses by investing in their locally developed long-term plans for mission, growth and sustainability. And you can read more about this in the Strategic Mission and Ministry Investment Board's annual report at GS MISC 1422. As we heard on Saturday, we're very aware of the financial stress many dioceses are taking, and so £200 million of additional support is available for dioceses over the next 9 years to help that journey to sustainability. Compared with the current triennium, this new time-limited support means an extra £100 million going into the diocesan economy in 2026 to 2028, directly in support of frontline mission and ministry, of which £36 million is reflected in the 2026 budget. The budget also includes some other implications of the Diocesan Finances Review, with the abolition of the 5 apportionment votes that Synod is used to seeing. The new, simpler and more transparent arrangements will ease pressure on diocesan finances, supporting them to increase clergy stipends. From the start of next year, the cost of national support and services provided by the Council, grants for the Anglican Communion, ecumenical bodies and clergy retirement housing will be fully funded through Commissioners' distributions. Clergy retirement housing is now shown as a separate line with a very significant increase, both in existing provision, but also funding a range of additional products and services to support stipendiary clergy with long-term saving plans, home ownership options, and access to financial advice. Mission agency pension costs will be met directly by the Commissioners. And finally, I want to talk about ministry, where we're working to support increased vocations, seeking to address the challenge of a reducing number of stipendiary clergy as those retiring or leaving ministry for other reasons exceeds new vocations. The main element of work in this area is around ministry training, where the new Ministry Training Fund will cover ordinands tuition fees, maintenance grants and expenses. This will be administered nationally, providing a simpler, clearer, consistent process for ordinands and also reducing the admin burden on dioceses. The budget also includes funding for leadership development, the Ministry Experience Scheme, which gives those aged under 30 an opportunity to consider their vocation to Christian ministry, training for lay ministers, and for those looking to minister to children and young people. At the conclusion of this debate, you will be asked to vote on the allocation of the Ministry Training Fund budget amongst dioceses. The Archbishop's Council Finance Committee has worked with dioceses to develop a formula based on clergy numbers, investment assets per capita, and population income, reflecting diocesan resources and sharing the costs of ordained ministry training. For this year and next, the budget will still include the maintenance pooling adjustment, which shares maintenance costs amongst dioceses as a retrospective adjustment, and this is one of the admin complexities we're looking forward to getting rid of. This budget is the initial implementation of the outcomes of the Diocesan Finances Review and the triennium funding process. This represents a substantial resetting of the Church's finances, simplifying financial flows, improving transparency, enhancing financial support for dioceses and parishes, and focusing on clergy well-being. My hope and prayer is that through these changes, we will reduce financial stress and encourage vocations, ministry and growth, revitalising our parishes for mission. I commend the budget to the Synod for approval and move the motion at item 21. Thank you very much.
The motion is now open for debate. The motion is now open for debate. The speech limit is 5 minutes. I call Rachel Jepson, followed by Nigel Bacon.
Rachel Jepson, Birmingham 252. Speaking as a member of Archbishop's Council, I would like to focus on the Strategic Mission and Ministry Investment Board, i.e. SMIB. It has become apparent to me during this group of sessions that many members are seeking clarity about SMIB and its outworking with our dioceses and parishes. It seems to me that there is a vital need for robust governance by each diocesan synod whose diocese is applying for funding. After all, this is a key role of trusteeship. Trustees are in a hugely privileged and responsible role, regardless of whether they are clergy or laity. In fact, in my opinion, trustee due diligence is a gospel imperative. Before the bid with its rationale is submitted to SMIB, I think that the strategy and exact allocation of resources should be debated and agreed by that diocesan synod. Then, that result should be communicated to SMIB. Similarly, successful applicants would commit to reporting to their diocesan synod on at least an annual basis for the lifetime of the funded project, as well as to SMIB. My understanding is that this wise and good practice is not currently widespread. This good practice would help ensure people across our diocese are fully engaged with the plans as well as being empowered. Additionally, SMIB would have a richer understanding of the effectiveness of their funding, especially in relation to our parishes. In my opinion, the sooner this was the case, the healthier, more accountable, more honest, more transparent, and more trustworthy would be the culture within which we all operate for the sake of the mission and ministry of God's Church. Therefore, my question to SMIB is, are you willing to consider my suggestion as an additional condition of successful applications?
Nigel Bacon, Lincoln 342. Thank you, Chair, for calling me. And may I preface the comments I'm going to make by strongly welcoming the way that the budget has been restructured. It's a lot simpler to operate, but I do want to explore one particular area. Our prayers for the departed at the start of Friday's session included mention of my friend, colleague here on General Synod, and fellow reader, Sue Slater, who sadly died in March. Members will remember Sue for her incisive contributions to debates, and especially in the areas of inclusiveness and the ministry of women and laity in general. In many areas of our country, the Church is increasingly reliant upon licensed and authorised lay ministers. That is not something to be regretted. I submit that it is something we should all celebrate. Lay and ordained ministers with their complementary callings, by working collaboratively, can provide a far richer and wider-ranging parochial ministry than either could do on their own. In my own diocese, as I expect will be the case in others, we place particular value on ordinands and readers being trained and formed together, sharing modules where these are relevant to both branches of ministry. In support of that, Sue had campaigned for central funding for the training of lay ministers in the same way as was and is the case for ordinands. In 2025, for the first time, £1 million was included in the Archbishop's Council's budget in the form of resourcing ministerial formation, lay ministry innovation grants, something that many of us welcomed as an initial step in the right direction. It is therefore deeply saddening that that funding has been halved to £500,000 under the proposals before us, and I am left wondering how much of that will actually be directed towards funding lay ministry in our diocese. I realise that difficult decisions have had to be made, and yes, I agree that we do need to increase the number of ordinands and invest in their training. But it is also important that we increase the number of vocations to lay ministry and invest in their training as well. We need to be honest and clear that this budget fails to do that, and it will fall almost exclusively to dioceses to bear the costs. Now, admittedly, those costs are lower than for ordinance, much lower, but they are real costs all the same. I share the view Sue espoused year after year. If we label something as ministry training, it should give due weight to training for all aspects of ministry. The table at paragraph 9 of GS 2411 shows a total of £29.2 million budgeted expenditure on ministry for 2026. But delve into the details of paragraphs 30 and 31, and it becomes apparent that all bar £2 million is actually for training ordinands, leadership development, and the ordinance-focused ministerial experience scheme. That leaves £1.5 million for ministry with children and young people, and £500,000 for lay ministry. In a year's time, when we come to consider the 2027 budget, I ask that the costs of ordained ministerial training be shown as one line in the top-level summary, and then training for lay ministry and children's and youth ministry be each shown as separate lines. That way, by giving us the visibility of our investment in those lines, the budget presentation may serve as a thorn in our collective sides until we give lay ministry the level of support it deserves and demands. Thank you.
To enable as many speakers as possible to participate, I'm going to reduce the speech limit now to 3 minutes. I'm going to call the gentleman at the back. Yes, thank you. And Neil Burgess.
Mark Miller, Durham 107. Thank you, Chair, for calling me. I am really pleased to see the increase in link funding that has come through this budget. I serve within the New Wine Network. I look after urban churches. We use the word urban to describe those places where life is hardest and resources are fewest. And I have told Synod before that I minister in the most deprived parish in my diocese, the Diocese of Durham. I am delighted at the way my diocese is starting to apportion link funding to the poorest of parishes, and we'll see how that plays out. But at the last group of sessions, Carl, I spoke to you about the importance of a big stick, which actually was reported in the Church Times. Only time I've been reported in the Church Times. The big stick being the way that we might deal with dioceses that do not distribute money from link in the way it should be. And we have heard in this synod that sometimes that happens. So I wonder if you might share a few words about the light touch reporting, how that will work in practice, and where you keep your big stick. Thank you.
Thank you, Chair. Neil Burgess, York 435, member of Archbishop's Council Finance Committee and the steering group for the Diocesan Finance Review. Synod, I'd like us to reflect quickly on two things that I believe are close to our hearts. Two things which I'm pleased to say underpin this budget. Firstly, consultation. This budget is based largely on the work of the Diocesan Finance Review, which involved extensive consultation with a really wide range of stakeholders. All diocesan secretaries, finance directors and DBF chairs. The House of Bishops, Archbishop's Council, Church Commissioners, Vision and Strategy Group, MINDEV, Diocese Commission, and yourselves. The second thing I think that's close to our heart is our duty to be wise stewards. The church economy is incredibly complex. And the numbers in this budget are the result of many hours of detailed work and cross-checking by experienced and highly competent people. I'd like to pay a special tribute to Joe and David and their team. They do a tremendous job, and these numbers can be trusted. Now, unfortunately, one of the spending proposals we considered on Saturday did not, for me, have this level of consultation behind it, or the careful modelling that befits wise stewards. And that's why when the modelling was done, the outcome was so drastic. It's less than 3 years, Synod, since a Conservative government tried to introduce financial changes in the budget without appropriate consultation, without detailed modelling. I think we all know how that ended. So I'd also like to make a little appeal, really. When we next review our spending plans, let us not have a Liz Truss moment. Let us again base our numbers on extensive consultation. Let us base them on the careful modelling that befits wise stewards. I'm delighted to say that those things are true for this budget, and I commend it to Synod.
Could I inquire if any of those standing are wishing to speak against the motion? If you could remain standing if you wish to speak against the motion. Yes, I'll call Ian Johnson and then Lucy Doherty.
Thank you, Chair. Ian Johnson, 387 Portsmouth. I am against this, I have to say in a marginal way, but I am against bits of it, certainly. Correlation synod is not causation, but in this case, I think it is. Since the 1998, the centre of our church has prospered, certainly, but our dioceses are now suffering hugely. And what's the reason for that? The National Institutions Measure 1998 is what it is. That's the problem. It made a dog's dinner of the Turnbull proposals, and the result is maybe unintended, but there nonetheless, is that next year some 32, I believe it is, of our 42 dioceses will be budgeting a deficit. Who on earth can be proud of that? The centre, I have to say, Carl, defends itself extremely well, and you've got a lot of work you do, and it is very well done indeed. But I would ask you to take note that the proposal for the redistribution of assets into, and if not assets, then proceeds of assets into the diocese in their stipends funds was lost, admittedly, but only very closely. I think we need to take note of that. It's not just another discussion that Synod had that it lost and is then discarded into the dustbin. It happened, it was close. And another 5 votes, one way or the other, and it would have gone through. The changes to the structure that we've had in the budget, without a doubt, are very welcome. They are long overdue, very welcome indeed. Thank you for that. And the changes to the stipends, to the pensions, the clergy retirement housing, excellent. A change to link, as has been mentioned, very good indeed, and so much else. But the problem is that our diocese, notwithstanding all the work that has been done recently, are still struggling. And speaking for mine, I think we've got some pretty difficult decisions to come up with in the near term. We have, I'm sure, had a pretty fundamental reassessment of where we are in terms of last time's TFWG. It doesn't matter how well we think we've done that. Frankly, the result says we haven't done it well enough. And we need to go into the next one with a completely clear mind, and it needs to be done from the diocese point of view, not from the centres. So while in general I absolutely support this budget, there are certain things about it which I think we have not done well enough yet. Thank you.
Lucy Doherty, Portsmouth 385, Portsmouth twice in one afternoon, gosh. Carl, thank you for this budget. I found it actually quite easy to read and understand, and I'm a bear of very little brain when it comes to finances. Just a couple of comments, speaking as a member of the Council for Christian Unity and as one of the 2 Church of England reps on the World Council of Churches. Page 9, paragraph 46. I read this and I thought, oh good, things are going the right way, they're going up. And then I turned to, well, I didn't. I got to page, whichever page it is. It's paragraphs 11 and 12 on page 16. And I'm really quite confused. Paragraph 11 talks about modest increases being made to the grants for some ecumenical instruments, for which the Council makes Church of England's contribution. And then at the end, it says that expenditure lines in this area to remain at the 2025 level, so no increases. And so I really want to know, are there any modest increases for what is already a very small budget for a very important part of our church's work, outward-facing, influence building, and which goes towards enhancing our credibility as a generous church which wishes to work across the breadth of Christian churches here and abroad? My question is the budget going up or isn't it? Thank you.
I'm minded to take 2 more speeches and then test the mind of Synod. The lady in the centre there, please. And the lady over there. Thank you.
Penny Allen, Lichfield 335, a member of the Diocesan Board of Finance. I just want to say thank you very much to Carl for the link in improved funding. That's very helpful in my diocese, and to know that real concentrations of poverty in the Black Country and in Stoke-on-Trent particularly are deserving of this funding, and that we are very grateful, and we record thanks today, and we also spend that money on those posts. Secondly, I want to talk about something that's actually got no relationship to me except for the complaints I receive, and that is about clergy housing. As you know, many people in my generation were advised to sell their own homes at the moment that they were ordained. This was a grave mistake. Unfortunately now they're in a position when they're retiring where they have few opportunities. I wonder whether shared equity scheme on the part of Charm would actually address some of these issues. I would say to you that from my point of view, I'm hearing of people having to use legacy money, I'm hearing of people having to get mortgages, and I'm hearing as well of extortionate rents that are now being charged. And I don't think members of the House of Laity would want people who've been living in tied housing all their lives to suddenly have these massive rental bills. And we tend to forget, because we own our own properties, the disadvantage they are now in the current housing market. I'm seriously concerned about that, and the fact that they're having to pick up mortgages or other top-ups for their income at a time when we are actually reviewing the Charm housing, and I hope a different scheme may be arrived at. I think it's very important that the House of Laity recognise the difficulties for clergy in these instances as well. And thank you to Carl for the 9 years that we can look forward and plan for. That is much improvement on the triennium funding. Thank you very much.
Mary Talbot, Europe 308. Thank you for calling me. I support the proposals wholeheartedly. I just wanted to ask a question about apportionment. Europe has a different model for paying for its clergy. And you've said that these proposals will help dioceses to fund their clergy. Our clergy are paid by the individual congregations. So I'm just asking that we are not penalised because there isn't a line in the diocesan budget for clergy stipends. We do pay our clergy, but they're in a different pot.
Thank you. I now wish to test the mind of Synod as to whether item 21 has had sufficient debate. I therefore put forward a motion of closure on item 21. For those in favour, please show hands or tick. Those against, show hands or red crosses. Those in favour. Those against? That is carried. I now call on Carl Hughes to reply. Carl has up to 5 minutes.
Carl Hughes, 467 Archbishop's Council. Synod, thank you very much indeed for that debate, and also thank you also for some very encouraging and kind comments. Let me just start off, Rachel, with your question relating to SMIBs partnering with dioceses. In terms of involvement of diocesan synods in SMIB bids, absolutely, I would fully support that. And I think, clearly each diocese does things differently, but I would have thought that consultation in advance of a bid going through and then basically reporting back to diocesan synods about what was then approved and then how that works out going forwards, I would have thought that would be good practice. And I'll certainly be happy to take that to the board. Nigel, indeed, Sue Slater is indeed very fondly remembered. In terms of the central funding for training of lay people, obviously we have set out in the budget statement the lines that you talked about, and those costs, those budgets are monitored and managed by the Ministry Development Board. We've probably not set that out in the most user-friendly form to make it clear what lay training is, and I commit to ensuring that we do better going forwards. I suspect there is actually some other lay training fund that might well be in another line. Okay, I don't know off the top of my head. Mark Miller, thank you for your comments about Link. I must admit I have gone for light touch rather than big stick. And, as we have said, we are hoping that dioceses will be more intentional and focused in their allocation of link, so that parishes are advised if they are beneficiaries of link, and diocesan synods are able to have an overview of how link is being allocated. Clearly, we will be looking to see how that works in practice, and then we may need to look at that again if dioceses are not taking that up. Neil, thank you for reminding us about the benefits of consultation and good modelling. Ian, the centre has prospered and dioceses have suffered. I'm not sure I would wholly agree with that. I'm not quite sure why you feel that 32 dioceses are going to be budgeting a deficit in 2026, because actually most dioceses haven't done a 2026 budget yet, and once you put into account the benefits of simplification, the abolition of apportionment, a huge increase in link, and the time-limited funding, I would be very disappointed if 32 dioceses were budgeting a deficit in 2026. Also, I would say that we were very clear on Saturday that we heard what Synod was saying in terms of future options for how we manage our finances. I very much welcome the Bishop of Sheffield's amendment, and we will be coming back to Synod as promised in the course of next year. Lucy, thank you very much for your comment. I have to say I definitely didn't know the answer to that question off the top of my head. The funding for ecumenical organisations went up by 3% in 2025, but has been held at that level for the 2026 budget. Penny, thank you very much indeed for your very kind words. Clearly, there is a lot of work that is going on around clergy housing. I am very well aware of the issues about people being asked to sell their homes. Shared equity schemes have been considered before, and that scheme has been closed. But we are following up on the items which you can see in GS MISC 1427. And Mary, apportionment in Europe, I have to say, it is always difficult when you're talking about the church as a whole, is that there are actually separate provisions that apply specifically to the diocese in Europe, and also sometimes to Sodor and Man. But we are very aware of the fact of the particular support needs of the diocese in Europe, and in fact Bishop Robert and I were talking about that just yesterday evening. So, well, thank you all for your comments.
Thank you, Carl. I now put item 21 to the vote. For those in favour, show of hands or green tick. Those against, show of hands or red crosses. Those in favour of item 21. Thank you. Those against? That is carried. We now turn to item 22. As Carl has already spoken to this item, I call on Carl to move item 22.
Chairman Carl Hughes, 467 Archbishop's Council, I so move.
Thank you, Carl. The motion is now open for debate. The speech limit is 5 minutes, but the limit will be subject to review as in the previous debate. Roy Faulkner, followed by Ian Poole. Sorry, Roy Faulkner first. He's just behind you, Ian, I'm afraid. He's behind you.
Oh, no, no, he isn't. I have been performed as a fairy once or twice in Cinderella, so there you go.
Too much information, Roy. Thank you.
Roy Faulkner, Leicester 333. This is just really a very short thing, Carl, a question more than anything else. I couldn't find in GS 2411 what the apportionment was going to be for the additional time-limited support, which is 63 million you mentioned for the 2026 budget. I found that the link apportionment was there, but I couldn't see how you were apportioning it to dioceses for the time-limited bit, which is quite a lot. Thank you.
Ian Paul 229 Southall and Nottingham, and I can say that I have never performed as a fairy anywhere in public. That wasn't an invitation for comment, thank you very much. I'm just coming to the end of serving my 10 years on Archbishop's Council, thanks to you, Synod, having elected me onto it. I think there's a joke to be made here, something about, you know, I'd have served less for some other kind of offence, but I don't know how appropriate that is. I've just done a quick check in my folders, and over that period of time, I've certainly read in excess of 2,026 papers. There have been times when being on Archbishop's Council has been extremely difficult. There's a sense in which Archbishop's Council is a kind of microcosm of Synod. So if you can take our 5 days in York and think about all the contests, all the controversy, think about some of those worst moments of people getting frustrated with each other and using every rhetorical device in the room, Archbishop's Council at times has been that, all wrapped up in one room with 25 people and crammed into a single day. So sometimes it's been challenging, but other times it's been incredibly encouraging. But I just want to notice that in our engagement with all these financial questions, there has been over the last few days a real danger of two sets of us and them. The first us and them is a perception that Archbishop's Council sits in tension with General Synod. I was one of the people, along with Carl, who are very concerned that the Archbishop's Council annual report should never be taken as deemed business. And in fact, I did write into the clerk to say it should be undeemed, because both the finance and the annual reports need to be scrutinised by you, Synod. And it's really important that they are. There is not this imagined difference between Archbishop's Council and Synod. Many members are elected by Synod, and Archbishop's Council and its successor bodies must be open to scrutiny. The second us and them is the us and them we've heard several times here between Archbishop's Council, those people at the centre, and us poor folk in the parishes. I'm associate minister of my church in inner city Nottingham. All the members of Archbishop's Council bring with them experience from the front line of ministry. This us and them, I'm afraid it's a myth, it's a parody, it's an unhelpful one, and it is one without justification. This report, the finance reports, the annual report yesterday, they're all part of a desire, a sincere desire, members of Archbishop's Council, to be transparent and accountable. Yes, it's perfectly right to ask hard questions. I do have a bit of a reputation for asking hard questions, and I think one or two of the people sitting behind me are aware that I'm not afraid to ask questions, and neither should you be. Ask hard questions, but also trust that the work has been done. I commend this item to Synod.
As I see no one else... Oh, sorry, I missed somebody. Oh, I'm so sorry. No, no. Thank you. Yes, please. Yes, please. Yes, sorry, and Sarah Tupling.
Thank you for calling me Chair. Trudy Oliver, Rochester 201. This is my debut speech, as clearly you can tell because it's cleared the room. stand before you today deeply grateful. Grateful for the opportunity to speak, and even more so for the journey that has actually brought me here. I was ordained back in 2009. That feels like a lifetime ago now. And I come from a very working class background. At the end of my discernment, I had just completed a part-time religious studies degree whilst working 30 hours a week and raising 2 children. My husband worked on the railway, taking every shift he could just so that we could make ends meet. This isn't a sob story, I promise you. So for us, entering full-time training at Trinity College was a massive leap of faith. It was something I felt deeply called to, not just because of the vocation itself, but because I'd never had that opportunity to study full-time before. Like many, I had left school early to help support my family. I had to go straight into work. For me, full-time study was a chance not just to learn, but to be shaped for ministry. But the cost was very real. During the move, my husband lost his job and was unable to find another one in Bristol. We managed, just through the help of child tax credits, as it was called back then, and the kindness of our sending church. There were many moments, though, when I felt guilty for not being able to provide the kind of birthdays or Christmases my children had known, guilty for even having to buy the blue striped food for dinner. And in those moments, I reminded myself that I was being supported by what we often call the widow's mite. The faithful, sometimes sacrificial giving of strangers across the Church of England made it possible for me and my family to be there. I'd never stopped being thankful for that. But we need to be honest about the realities. As was mentioned, I think it was Saturday, though time has started to blur massively. There is a month where ordinands are simply left without any support. I was never told about that. I found out through another ordinand just a month before leaving college. You can imagine my shock. It's been suggested ordinands can save up during their training to cover that month. Respectfully, I doubt that very much. When you're in training and don't have the support of a spouse in work, every month is tight. There isn't room for a missing month. But even more importantly, ordinands deserve to be told about this gap clearly and early so they can prepare or even consider how they train in light of it. It's not just a budgeting issue, it's a formation issue. When someone answers God's call and steps out in faith, especially those from less financially secure backgrounds, we as the church must make sure we are not adding unnecessary burdens to that obedience. I am deeply grateful for Trinity College, for my sending church, and for every anonymous giver who made my training possible. But let's not leave others walking that same road in the dark about what lies ahead. Let's be transparent and pastoral. And above all, let's make sure that no one is excluded from answering God's call because they simply cannot afford to say yes. Thank you.
So Sarah, 471, DAT rep from the 3 DAT reps. I could be a fairy. Anyway, seriously, I'm going to try and be brief this time. You know, I keep standing up and going on about deaf issues. And again, I think it is important within this context to mention training and ministry funding. But let's go back a bit. We talked about the budgets, and I really appreciate that work. But what I would love to see is to ensure that always within that budget there is training and provision for deaf ministry training and disability training of ministers, of lay workers, and so on. Thank you.
The gentleman at the back with the orange T-shirt. Anybody else wishing to speak?
If only I was a fairy, I could have flown down. William Woolley, Southall and Knott, 420. Thank you very much for this budget, and I broadly welcome it as someone who is stepping into being an ordinand next year. One of the things I think it deals with, or is going to deal with, is clarity around what grants actually look like. I'm in a situation now where this is there's going to be this interim gap of we're moving to something to support people starting this year. But what's interesting is I still actually don't know what it is. And I quit my job and don't get another pay slip going on in September. I've had ballpark figures, but that is about it. And as discussed yesterday, I don't have a middle-class spouse. I have a spouse who works for the church as a layperson who has also been left behind in this budget. So I welcome this change because actually clarity of what will happen when we become an ordinand in advance would be very, very useful. And I think actually as a pipeline that we're talking about, actually the pipeline of ordinands has stopped. I actually would say this is one of the biggest things, actually. I've had to take a leap of faith with a mortgage and a child, not really knowing what my funds will look like in September still. And September is all but 2 months away.
As there are no further members wishing to speak, I'll call on Carl Hughes to reply. Carl has up to 5 minutes.
Carl Hughes, 467 Archbishop's Council. Again, thank you everyone for your contributions. Roy, the apportionment of time-limited funding on the formulaic basis of £25 million for 2026 can be found in Appendix 4 of the budget paper. The additional £11 million relating to time-limited funding will be distributed through DIP by the Strategic Mission and Ministry Investment Board. Ian, thank you for your comments. I would just say I would totally support having an annual debate on the Archbishop's Council annual report and the Audit and Risk Committee report, as would be the case at the annual general meeting of any public company. In terms of us and them, I must admit, sometimes I do realise that I am clearly them, but all I would encourage you all is that I seek to be as accessible to you as I possibly can be. If you email me about any subject, I will always respond. For me, this role is all about transparency. There's nothing hidden in smoke-filled rooms in Church House. So please do engage with us. And as I think has been the case, for example, on clergy pensions, just the level of engagement has actually just meant that we've been able to come up with an excellent solution. Trudy, well done on your debut speech. Sadly, your story of financial hardship during training is not uncommon. and we are very well aware of the missing month issue. However, I really do anticipate that the significant increases that we're making in ordinand maintenance allowances will materially address this, and I hope reduce the level of hardship generally. And also, there is also, of course, the first appointment grant that is available to ordinands, which also would help around the missing month issue. So while I'm on that, I'm now going to skip to William, and I mean, I am just really sad to hear that you are in a state of, not really knowing what's going to happen next. And certainly what we're trying to put in place, looking ahead to 2026, is that by managing all the fees, maintenance allowances and travel expenses centrally, nationally, you will have, as a new ordinand, a one-stop shop where there will be people who will be able to address the questions that you have on a consistent basis for the whole country. And I really, really believe that will make a huge difference. In terms of the grants for this coming year, because some of that is dependent upon the approval of the triennium spending plans this weekend by General Synod, the proposals for next year's for September's intake maintenance grants, that will be going to Archbishop's Council a week on Tuesday, and then after that, that will be communicated by the Ministry Development Board. If you've got any further specific questions, do get hold of me or Nick McKee, who I know is around. So we need to have greater clarity. And finally, Sarah, I am sure that the people in faith and public life will have heard the point that you make, because that is the department that determines how the budgets set aside for deaf ministry are spent, and we will just draw their attention to the points that you have made. Thank you very much, Senator.
Thank you, Carl. I now put item 22 to the vote. Again, those in favour using hands and ticks on Zoom, or red crosses and hands in the chamber. Those in favour of item 22, please show. Those against. Item 22 is carried. We move now to the next item of business, the election rules.
Friends, welcome. We are now going to be dealing with items 511 through 515. I feel the power of being the only person between you and your supper, so that's very exciting. Just to say that there's a variety of, on the first item, there will be a variety of voting methodologies. So we have to introduce the item through a show of hands, but the final passing of that particular motion under the representation rules requires a counted vote by houses, but we will flag that up for you when the time comes. So this is item to start 511, the Church Representation Rules Amendment number 1, Resolution 2025. Members will need the resolution and the explanatory notes, and to be carried, item 511 must be passed with a majority in each house of not less than 2/3 of those present and voting. As there is an amendment, indeed a number of amendments, the procedure will be as follows. First, Mr. Scowen will move item 511A, the preliminary motion that the rules be considered. This will provide members with an opportunity to make general comments about the rules or to raise specific points which do not relate to the amendment on the order paper. If the preliminary motion at item 511A is carried, we will then take the amendment. So I therefore call Mr. Clive Scowen to move item 511A, that the Church Representation Rules Amendment number 1, Resolution 2025 be considered. He may speak for up to 10 minutes.
Thank you, Chair. For the record, I have never been a fairy, either in public or in private, but I was once Grumpy the Dwarf. None of which has anything to do with what I'm about to say. At the beginning of each quinquennium, the Business Committee appoints an elections review group to review the conduct of the last General Synod elections and propose changes to the rules which it believes will remedy issues which have been identified. This is the primary task of the elections review group, although it acquires many other tasks as well along the way, as you will discover tomorrow morning. The business before Synod this afternoon is the fruit of the group's work on that primary task. And before I go further, I'd just like to thank the other members of the group for their support, Paul Cartwright, Nick Tall, both elected by the Business Committee, Catherine Stevenson, Prudence Daly, and Peter Worry, the Diocesan Secretary of York, all appointed by the Appointments Committee, and some of them are sat behind me. In order to give plenty of time for Church House and diocesan staff to prepare for the 2026 General Synod elections, these rules were on the agenda in February, but they were deferred because of lack of time. If preparations are now to be made in a timely fashion for next year's elections, it is vital that this business be approved at this group of sessions. Now, it consists of 5 pieces of legislation: the Church Representation Rules Amendment number 1 resolution, House of Bishops election rules, the House of Clergy election rules, House of Laity election rules, and the Single Transferable Vote Amendment rules. I hope everyone will have read the excellent explanatory note, GS 238892X, which explains this suite of rules very clearly. Anyone who has not will just have to listen to me. The Church Representation Rules Amendment Resolution contains amendments to the Church Representation Rules, and the STV Amendment Rules contain minor amendments to the STV rules. But the 3 sets of election rules, which set out the procedure to follow in the elections to the 3 houses of Synod, completely replace the old rules for each house. The group began its work by seeking submissions from members of General Synod, the NCI staff involved in preparing for the 2021 elections, and in some cases in running them, the diocesan secretaries and registrars, and other diocesan staff involved in running the elections locally, and Civica, which provided the electronic voting portal. The 2021 elections were the first to have had fully electronic voting for most constituencies, including all 84 diocesan constituencies. The review group in the previous quinquennium had worked hard with Civica to design a portal to meet our needs, but when it came to it, a number of unforeseen issues arose, which we have now sought to address. One problem was that Civica was having to engage with 42 separate diocesan clients, each with their own contract for which they had paid, and 42 subtly different election timetables, compounded by the fact that the Church of England website published an indicative timetable which showed deadlines which were not always the same as those on diocesan websites. So we are proposing two changes which are unashamedly centralising. A national contract between the Archbishop's Council and Civica, which will cover all 84 diocesan elections and any by-elections to be conducted in the course of the quinquennium that will follow, and a national timetable which all dioceses will have to follow. After extensive detailed consultation with both Civica and the diocese, in particular the diocesan secretaries, we're satisfied that what we propose will work for both Civica and the diocese. As things stand, the next dissolution is expected on the 14th of July 2026. It's exactly a year today, with the 12th General Synod being inaugurated on the 17th of November of that year. The election period will begin on the 14th of July and end on the 19th of October. And while any voter who wishes to nominate and vote on paper and by post will continue to be entitled to do so, the vast majority of voters are expected to use the online elections portal. Turning then to the Church Representation Amendment Resolution, which requires a two-thirds majority in each house in order to be carried. The substantive provisions which are set out in paragraph 2 of the resolution relate to the timetable for elections to the House of Laity. They change the length of the elections period from 3 months to 100 days, require the laity elections to be carried out in each diocese in accordance with the national timetable set out in the House of Laity election rules, impose a new duty on the presiding officer to send all lay electors a preliminary letter about the election process, move the provisions about inspection of the register of electors from the church representation rules to the laity election rules, and require each invitation to make a nomination to specify that the name of each person nominating a candidate will appear alongside the candidate's name on the invitation to vote or ballot paper. So that is the first matter we have to deal with, and I move that the Church Representation Rules Amendment number 1 resolution be considered.
Thank you, Mr. Scowen. Item 511A is now open for debate. The speech limit at this stage is 5 minutes.
Catherine Stevenson, Leeds 330, speaking as a member of the Elections Review Group. As a member of the laity standing for the first time in an election to General Synod in 2021, I found the experience simultaneously exciting, extraordinary, and enlightening. I wondered whether other candidates felt the same and how our collective experiences might shape a better, fairer, kinder, and more constructive process for future elections. I was especially keen to explore how that process could better support new candidates, making sure people feel fully informed and that there are no unnecessary or obvious barriers to standing for General Synod, especially in the houses of clergy and laity. Consequently, in November 2021, I submitted my very first question to Synod: would there be a review of the 2021 General Synod elections? I was delighted when the answer came back yes, and I was very grateful and a little nervous when the Appointments Committee, noting my interest, invited me to join the newly formed Elections Review Group. It has been a real privilege to serve on that group. I have learnt so much. The review group's remit turned out to be far broader than I imagined, not only drawing up the comprehensive legislation before us today and tomorrow, but also taking the worthwhile opportunity to consult nationally on PCC membership and developing much clearer and more helpful election guidance for dioceses. Much of what I've learnt has come from the generous insight of experienced Synod members, Clive Scowen, Prudence Daly, Nick Tall and Paul Cartwright, York's Diocesan Secretary Peter Worry, and from the outstanding staff at Church House, especially Jenny Jacobs, Chris Packer and Alex McGregor. Speaking in particular to newer members of Synod who may be wondering whether to get involved in committee work, I highly recommend it. Be assured your contributions will be heard and valued, you'll be well supported, and you'll discover just how much good can be achieved when people and processes come together to make positive, meaningful, worthwhile change for the life and witness of the Church. Please wholeheartedly support this item before us.
Thank you. I didn't see anybody. Oh, yes, sir, if you'd like to come down. Thank you.
Ian Johnson, Portsmouth 387. Very briefly, if Civica is going to be the single supplier, where are you? If Civica is going to be the single supplier of our election services, how do we prevent price gouging?
Thank you. In the absence of anyone else standing, could I invite Mr. Scowen to respond to the debate? Clive, you have up to 5 minutes.
Chair, I guarantee not to take 5 minutes. Firstly, Catherine, thank you. Who could possibly disagree? It's nice to be appreciated, and everybody up here, especially the staff, really appreciate that. Thank you so much. Ian, I am advised that Civica already give us a very significant discount. They work for a variety of different organisations. We are a charity, as many of their clients are, but they have given us some very favourable terms, and I wouldn't want to do anything to upset that. That said, please do support to consider these rules, this resolution.
Thank you. I now put item 511A, that the Church Representation Rules Amendment number 1, Resolution 2025 be considered, to the vote. This is by a show of hands. So those in favour, please show, and a green tick on Zoom. Thank you. Those against? That is carried. I'm now going to move on to the amendments. So I'm first of all, if I could call Mr. Sam Margrave to move his amendment, item 544. You have up to 5 minutes, Mr. Margrave.
Sam Margrave, Coventry 295, thank you. Synod, this amendment is about removing a barrier that excludes far too many from standing, not because of a lack of calling, but because they lack access. Requiring a proposer and seconder may seem routine, but it creates a real burden for new people, often. Administratively, relationally, and financially, it can exclude faithful people in our pews who have never met a deanery synod member and may worship in a parish without a lay representative, so no connection to somebody. How do you even contact a deanery synod representative to nominate you if you don't get an elector list before the nominations, or you don't know anybody who knows somebody? Those impacted are often younger people, disabled people, or those from smaller or less connected communities, and they have gifts that we desperately need on this synod. I speak for experience. When I stood for synod, I wasn't on a deanery or diocesan synod, and someone kindly nominated me and sorted out all my nomination paperwork, and I wondered, what if they hadn't done that? and how many others has the current system quietly turned away? This amendment isn't about weakening scrutiny. Deaneries will still rightly elect who they believe is fit to serve. But this nomination process, without having to get a seconder and proposer who may not even know you, just for the purposes of signing a form, would allow anyone to put themselves forward without having to find 2 deanery synod members. As academics Clark and Benster write, nomination requirements act as a significant gatekeepers, reinforcing insider privilege and deterring participation from the less networked. The Electoral Reform Society also says and found that such rules can entrench inequality, and the Joseph Rowntree Foundation has also warned that they disproportionately exclude disadvantaged groups. Our own church has recognised this, say in Setting God's People Free, that urges us to break down barriers to lay leadership. And I see our role on Synod as a form of lay leadership. Let's do all we can to break down barriers and increase the number of candidates standing and encourage underrepresented groups. I also want to affirm how incredible deanery synods are and how incredible deanery synod members are. And I've been proud to serve for 15 years at their pleasure on General Synod, and we must encourage more people to stand for deanery synods too. But that doesn't mean our elections to this synod should depend on knowing somebody on the inside. Let's trust the laity, let's open the door wider, and let everyone come in when they knock. I will also be asking for a count of the whole synod, and I move my amendment, standing in my name, and please ask for others to support this. Thank you.
Thank you very much, Mr. Margrave. Could I call then on Mr. Scowen to speak for not more than 5 minutes in reply?
Chair, I want gently to resist this because I do actually want to know whether this has significant support before we take time debating it. Mr. Margrave may be right that more people might stand if they didn't have to get a proposer and a seconder. But the question is whether people who entirely self-nominate without anybody else to support them are likely to be supported by anybody else when they stand for election. We have, since time immemorial, required proposers and seconders. And those of you who stood for General Synod any time before 2015 will remember having to hawk your form around people, send it by post and so on, so that because they had to get 2 signatures. And that, I think, certainly was something of a barrier. We have moved quite a long way from that. The system we now have is, in effect, self-nomination. The candidate puts their form in with their own consent and puts down 2 names of people who have agreed to support them. Those people don't have to do anything. They're contacted by the office who just to inquire whether they are indeed willing to support them. If they don't hear anything, then they are deemed to be supporters. So it's almost self-nomination, and it actually requires at least one of those 2 people actively to say, no, I didn't agree to support X, in order for the nomination to be in any way queried. So I do think we have significantly reduced the barriers that are there. Now, I think it's always a problem when people have had no involvement with synodical life because, as has been said, you don't necessarily know how to go about anything. From the centre, we will be producing materials to encourage people to stand for synod, and I think it would be helpful if those materials were to include some practical guidance on how best to secure the proposer and seconder that you need. I think that the discipline of requiring some indication of some external support is a good one in principle, and the easier we can make it to do that, which I think we have done, the better. Now, if Synod wants to take a different view, you're welcome to, but my view at the moment, and I think the view of most of the Elections Review Group at least, is that we should keep this current system unless you very affirmatively want to say something different. So I do want to resist this so that we can see whether 25 people support it, and if they do, then obviously Synod will get to vote on the matter. Thank you.
Thank you, Mr. Scowen. Well, Mr. Scowen has resisted the amendment, so therefore the amendment will lapse unless at least 25 members indicate that they wish the debate on the amendment to continue and a vote to be taken. Do I have 25 members standing? I'm afraid we don't have 25 members standing, so item 544 will lapse. If you'll just excuse me just to get my numbers right before I confuse you completely. So, in which case, could I ask Mr. Scowen to move item 511B, that the Church Representation Rules Amendment Number 1, Resolution 2025, be approved.
Chair, I do so move, not having made any amendments. It's simply a matter now for Synod, if it wishes to continue to debate the merits of this amendment resolution, or if not, we can vote on it.
Thank you. Because of the nature of this legislation, I need to put item 511. Oh, I beg your pardon. It's open now for debate, should anyone wish to debate this item. No, I see no one standing. In which case, I call a counted vote by houses on item 511B. Okay. Yeah, all right. So this is the one. And this will have to be by a 2/3 majority in each house in order to be carried.
I'm about to ring the bell to warn members that the counted vote by houses is to take place. 2 minutes after it ceases, the counted vote will begin.
This is a counted vote by houses on item 511B. Those present in Central Hall using the voting handsets and who wish to vote in favour should press 1. Those against should press 2. Those who wish to record an abstention should press 3. Those participating remotely should use the online voting platform and vote or register an abstention using the buttons on the screen. A majority of not less than 2/3 of the members of each house present and voting is required.
The voting period is now open and will end in 1 minute. The voting period will end in 15 seconds. The voting period has now ended.
The result of the vote was as follows. In the House of Bishops, in favour 19, against 1, recorded abstentions 0. In the House of Clergy, in favour 96, against 1, recorded abstentions 0. In the House of Laity, in favour 139, against 2, recorded abstentions 1. The motion was carried in all 3 houses. The resolution will now be laid before both Houses of Parliament pursuant to the Statutory Instruments Act of 1946. We now move on to item 512, taking the House of Bishops election rules. Members will need the rules and the explanatory notes. There are amendments on the order paper. These have been grouped together under 2 item numbers as the amendments in each group stand or fall together. I first call on Mr. Scowen to move item 512A, that the House of Bishops Election Rules 2025 be considered. He may speak for not more than 10 minutes.
Thank you, Chair. I'm going to say something about the 3 sets of rules before specifically addressing the House of Bishops rules. The 3 sets of rules set out for each house the national timetable for the elections. Each timetable begins with the expected dissolution date, and the subsequent steps are reckoned by the number of days after the dissolution. In contrast to previous elections, the archbishops will no longer set the election period, and dioceses will have little flexibility to alter it. Each diocese and other body involved will post online an election timetable specifying the actual dates for each stage. We hope that that will give maximum clarity and minimise the risk of confusion for the electorate and potential candidates. Nomination must contain prescribed information about the candidate, which, where there's an election, will be displayed on the election portal or ballot paper. They include any commonly used name and any title or post-nominal letters the candidate wishes to include, the name of each of the two persons nominating the candidate, and the candidate's postal address, although the candidate can ask for that to be withheld if there is a good reason, such as where a candidate has been a victim of stalking. In reality, if a candidate wants their name, their address withheld, that will happen. For the avoidance of doubt, each set of rules will now state expressly that a nomination received after the closing date will be invalid. It may be surprising to think that was necessary, but apparently it is, so that is what it does. The rules clarify the kind of election material which may or may not be distributed during the election period. A communication will be defined so as to exclude the election address, which each candidate is entitled to circulate, and any record of a hustings event which the presiding officer has authorised, meaning that there is no restriction on the circulation of those documents. The rules do not impose any requirements as to whether there should be hustings or what form they should take. Instead, those will be matters for each presiding officer to determine. Non-statutory guidance will be given about the possibility of a written question and answer procedure in addition to or as an alternative to hustings. Now, the House of Bishops election rules are the simplest of the three sets of election rules. Not, I hasten to add, because there's anything simple about the bishops, but simply because it's a simple sort of election. It's just the election of the 9 suffragan bishops, 5 from the southern province and 4 from the northern province, to serve in the upper house of the convocation of that province. And which obviously therefore makes them members of the House of Bishops. And that's really all I need to say about these specific rules. So I move that the House of Bishops Election Rules 2025 be considered.
Thank you, Mr. Scow. That item is now open for debate. I don't think I see anybody standing, and nobody on Zoom. So in which case we now come to a vote on item 512A. There's no reply from Mr. Skern because there's nothing for him to reply to. So we now move straight to a debate. So straight to the vote. So those in favour of 512A, please show. And with green tick online. Those against, please show, red cross. That item is carried. We now come to the amendments, and once again the 25-member procedure will apply to those. So if you'd like to, Mr. Margrave, could you remove your amendments under item 546, and you can speak for not more than 5 minutes.
Sam Margrave, Coventry 295. I withdraw amendment 546 and also 548. Thank you.
Thank you very much. Let me just quickly check our numbering again to make sure that we continue in the right order. Mr. Margrave, could I just clarify you meant 547 rather than 548?
Am I okay to approach the...
Thank you. Sorry for that lack of clarification. So we do now move to item 547. And I'm inviting Mr. Margrave to move on that one.
Again, this is for the House of Bishops. I apologise. I put three, Sam Margrave, Coventry 295. I want to apologise. I put 3 amendments forward, and thanks to the help, and it is genuinely appreciated, it was taken that maybe I would want to put all of these things for every house, and I was just trying to increase participation in the laity. So I will also withdraw 547. Thank you.
Thank you, Mr. Margrave, very much. Okay, so we are now going to move on to So I would now ask Mr. Scowen to move item 512B, that the House of Bishops Election Rules 2025 as amended be approved.
Chair, I so move.
That item is now open to debate. No, I see no one standing, in which case I put item 512B to the vote, that the House of Bishops Election Rules 2025 be approved. A show of hands, those in favour, and a green tick on Zoom. Those against, and a red cross on Zoom. Thank you, that is carried. Right, we now move on to item 513, the House of Clergy Election Rules. And again, there are amendments on the order paper. The procedure will therefore be the same as it was for the House of Bishops Election Rules. These amendments have been grouped under 3 item numbers. The amendments in each group stand or fall together. So could I first ask Mr. Scowen to move item 513A, that the House of Clergy Election Rules 2025 be considered, and again he may speak for not more than 10 minutes.
Thank you, Chair. Before I begin, I wonder if I could ask you to confirm with Mr. Margrave whether he actually intends to withdraw 549. Thank you, Chair. In which case, as I understand it, I don't need to move 513A, and we can move... Oh, sorry, no, we've got...
You do need to move it, Clive, please.
You're quite right. Getting ahead of myself. The elections rules for the houses of clergy and laity each specify that the preliminary letter, which the presiding officer will have to send to each elector, will set out the timetable and process for the election, invite electors to update their contact details and change their preferences for online participation if they wish to do so, inform them how Civica will communicate with them during the election process, give each elector an opportunity to require the postal address, their postal address, not to be included on the electoral register, and to set out the grounds for disqualification for standing for election. Members may recall that in February, Prudence Daly had tabled amendments to the clergy and laity rules to require the presiding officer in a diocesan election to contact each person who had been elected to General Synod to ask for permission to publish that person's email address on the diocesan website. Because the business wasn't taken in February, it gave the Elections Review Group the opportunity to consider those amendments, and with the consent of the Business Committee, we did agree them, and they're now incorporated in the rules before us. Elections to the religious communities constituencies will continue to be conducted on paper only rather than online. That said, a number of changes to the procedure for nominations and voting will apply to those constituencies as well, mainly to bring them into line with other constituencies. And the invitation to give a commonly commonly used name will extend to the candidate's name in religion and title. The House of Clergy election rules are the longest and most complex, not of course because clergy are either long or complex, but because in addition to diocesan representatives, the clergy have special constituencies for deans, for clergy working in universities and TEIs, and for clerical members of religious communities. The conditions for qualifying as an elector in the universities and TEI constituency of the House of Clergy will change in order to bring that constituency into line with the others, which will mean that a correction to the register of electors may only be made up to the close of the period for nominations rather than the close of voting as at present. The nomination forms for clergy will require the candidate to state the ecclesiastical office currently held by the candidate, or in the case of a candidate in the universities and TEI constituencies, the position held in the institution in question. And that information will appear on the electronic voting form and ballot papers. So with that brief explanation, I move that the House of Clergy election rules be approved. No, be considered.
Be considered, yes, indeed. That item is now open for debate. So.
Aidan Hargreaves-Smith, London 356. Chair, as a diocesan registrar and by virtue of that office, a presiding officer, you will understand that I and many registrar colleagues have a particular interest in the business now before us. I'm grateful to those who have worked with characteristic conscientiousness to produce these legislative proposals and the supporting material. And my observations now relate to common aspects of both the clergy and laity election rules. I am a little concerned about the imposition on all dioceses of a single fixed timetable, removing the modest but helpful degree of flexibility currently available, whereas at present key points in the election timetable may be timed to fit in with the working patterns of diocesan colleagues, for example, that will no longer be possible. Moreover, where some dioceses have sought to maximise the periods for nomination and for voting, extending them beyond the statutory minimum, that will no longer be possible either. And indeed, the new nomination period will be significantly shorter than the current minimum period. It's helpful to have the timetable set out in the various sets of rules. However, that timetable does raise for me a number of questions. The first is the expectation that the diocesan electoral registration officer will have given the names and addresses of electors to the secretary of each deanery synod by 5 p.m. on the day on which the general synod is dissolved, as I understand it. Now, I know that some members believe that the world hangs on our every word when we're here, but whether Deros will be ready to spring miraculously into action is unclear to me. It seems to me that the timetable has a number of pinch points which are not immediately clear from the table set out in the rules. For example, it may seem reasonable to have a period of 15 clear days between the presiding officer sending the initial letter to each elector and the issue of invitations to nominate, except that, as I read it, the electors have 14 days in which to respond to the initial letter. So that has the potential to make for a very busy Thursday, the 13th of August, 2026, for presiding officers and colleagues, and indeed for Civica. Similarly, it appears to me that there will be a maximum of 4 working days, and possibly, one might argue more realistically, 3, on which the counts may be held. And it will be reassuring to know that Civica has understood this and confirmed that it can resource the large number of counts, potentially 84 for the diocesan elections alone, in that very short period. I can see the benefit of the issue of the new initial letter to all electors, but it would also seem to be an additional administrative burden, particularly given the requirements in the proposed rules and the hybrid nature of the elections in most dioceses, with the need to run both electronic and paper-based processes alongside each other. The rules seem to me to be unclear as to whether the initial letter may be sent by email where an email address has been provided, and clarification in that respect would, I believe, be very welcome. Is the requirement to send details of the name of each candidate, the name of each person nominating that candidate, and any election address to those electors who have not provided an email address as soon as reasonably practicable after the close of nominations? That's in the Laity Rule 11.1c and the Clergy Rule 33.1c. In addition to the requirements relating to the issuing of invitations to vote, Laity Rule 15, Clergy Rule 38, notwithstanding the fact that there may only be a few days between the two. I'm sorry to detain the Synod briefly with these technical points, but hope that a perspective from practical experience will be of some assistance as we prepare for the major undertaking of a full set of General Synod elections. I shall support the consideration and the approval of the rules, with thanks to the Provincial Registrar for Elections and a plea generally for sympathy to presiding officers trying to implement them next summer. Thank you.
Thank you, Mr. Hargreaves. I don't see anyone else standing, so if I invite Mr. Scowen to respond to that, please.
Thank you, Chair. We did, as part of the preparation of this work, consult very widely with dioceses, with the national team, and with Civica. I think we probably assumed, and maybe we shouldn't have done, that when we consulted with dioceses, they would have consulted their registrar if the registrar was the presiding officer. In some dioceses, the presiding officer is the registrar, in others it's the diocesan secretary or somebody appointed by him or her. But we did consult very widely. Civica assure us that what we're asking for is entirely possible. A lot of the sending out of documentation is done electronically, certainly for those who are participating in the portal, which is the vast majority of electors. And we are as satisfied as we can be that there won't be a problem. However, we do know that this is a complex process that dioceses only engage in once every 5 years. And so each time there is, after we have approved the rules, a further round of consultation and education. In the autumn, I think, non-statutory guidance will be prepared to help all those presiding in elections to understand what they're being expected to do. That document itself will be circulated around the diocese and the registrars for comment, and will be revised in the light of comments we receive. Then next year, early next year, there will be a consultation exercise, again in person, I think, but certainly a consultation exercise at Church House for people to come and hear how things are supposed to work, and again to feed back. This is an iterative process. This rules bit is just the first stage. It's the only bit Synod gets involved with, but there is an awful lot more to do, which is one of the reasons it's so vital to get this agreed today. And specifically to Aidan and any other diocesan registrars who are presiding officers here, could you send your points in to us, to Alex, and they can then be dealt with in the non-statutory guidance. So where particularly Aidan thinks things are unclear, that will be clarified in the guidance, and I hope that will satisfy him and others who may have been concerned that this is a reasonable, workable scheme, which we think will be far less confusing to the electorate and to the candidates. And so I hope you will now vote to consider these rules.
Thank you, Mr. Scone. And I put item 513A to the vote. Those in favour, please show, or green ticks online. Thank you. Those against, please show. Again, indicate red cross online. That is carried. Mr. Margrave, having withdrawn items 548 and 549, we then move on to the amendment 550. So if I could call Mrs. Gregory to speak to that. Thank you.
Emma Joy Gregory, 247 Bath and Wells, also known as the woman with the noisy baby. I've submitted 3 amendments this afternoon. The first 2, that's 550 and 554, so you might need to turn the page for 554, are about publishing the postal addresses of a candidate on the voting paper or portal. First in the case of the House of Clergy, and second in the case of the House of Laity. So my speech is going to combine both of those. My second amendment, which I will speak about later, is about publishing a layperson's parish on the voting paper or portal. So in this speech, I'd like to cover both items 550 and 554. So, the first speech. We're living in a time where personal data is one of the most valuable and vulnerable commodities. It's frequently stolen, misused, and exploited, and at risk from leaks by large corporations. And when breaches occur, individuals are placed at significant risk. Now, I understand this can be difficult to fully grasp. Like most of you, I grew up with the BT telephone book, where you could simply look up someone's name, address, phone number, freely provided in the weighty tome put through your letterbox by the telephone company. Everyone's information was there, accessible to anyone, but times have changed dramatically. So why in this day and age are we suggesting that a candidate's home address should be published at the point of a general synod vote? There are serious and potentially harmful consequences to this. To start with, information based on an address could lead people to draw conclusions or make judgments that are not helpful in the context of an election. My address indicates the part of town I live in. My address indicates whether I live in a flat, whether I live in a house with a number or a name, all of which give away instantly my socio-economic status. I also question how this requirement aligns with our desire to attract a more diverse range of candidates, including those from the traveller community. Would this requirement deter them from standing? Of course, in the case of clergy, their addresses may well be in the public sphere already, whether they like it or not, but this is absolutely not the case for laity. Of course, a person's address is not a total secret, especially in the case of clergy, but what is the actual purpose of publishing an address at the point of voting? Is it so electors could write a letter to us? Well, I suppose that's fine, but does it really happen much anymore? Yes, the rules do allow that a candidate could request that their address not be published if they are, for example, a victim of stalking. That helps to a degree, but to me that doesn't go far enough. Those of us who serve on General Synod are not members of Parliament. We are normal people. Sort of. Normal members of the pews who are giving up our time, our holiday, to do something useful, to speak into the governance of the Church of England. It doesn't make us public property. I do understand the principle of transparency behind this proposed change, but let me end with a sobering reality. When you serve on General Synod, sometimes people can be awful to you. Sometimes people contact you and communicate in terms which are far stronger than you would welcome. Sometimes this crosses the line, and I know some people in this chamber have experienced such encounters from members of the electorate. So if we're serious about encouraging a broader, more diverse, more representative synod, one that reflects the full richness of the Church, we must remove any unnecessary barriers. Publishing home addresses at the point of voting is a potential deterrent to future candidates, whether clergy, in the case of item 550, or laity, in the case of item 554. So I move this amendment and ask you to vote for it.
Thank you, Mrs. Gregory. I now invite Mr. Scowen to respond to that speech.
Thank you, Chair. Again, I'm going to resist this amendment. As Mrs. Gregory accepted, any candidate who does not want their postal address published can ask for it not to be, and it won't be. It's very similar to the situation in secular elections. If you go along to the, well, I don't know if you ever do this, but if you go along to the polling station and having cast your vote, or perhaps beforehand, you read the notice with the names of all the candidates, you'll see a number of them have got their postal address published and others say address supplied within the relevant area. So if it's your local authority election, it says it certifies an address within the local authority area but doesn't actually give it. And this would be a very similar situation here. No, we're not MPs, but we are holders of a public office. And people who stand for General Synod are seeking election to a public office. And I think it's right in principle that their addresses should be available, as I say, subject to this very important right to withhold it if you want to. One reason it might be valuable, and Mrs. Gregory seems to feel this would be a negative thing, but actually some people might want to cast their votes on the basis of geography. They might want to vote for people in different parts of the diocese so that they can, can ensure representation across the diocese. Maybe many of us think that's unlikely, but it's important that people who feel that way should be able to do that. So, I mean, this is not a ditch that any of us want to die in, but once again, I think it's important that before we take time debating this, that we see whether there is sufficient support for it. So I am going to resist it and see what happens.
Thank you. Mr. Scowen, having resisted the amendment will lapse unless I see 25 members standing and wanting the debate to continue. We do have 25 members standing, so that debate will now be opened on the amendment. Please, if I see anyone standing who would like to speak. So who should we go for? Lady there in the black T-shirt, followed by you, sir, in the... Yeah, thank you.
Thank you, Chair. Diana Tremaine, Leeds 331. I think I just wanted to echo Mr. Scowen's points from a personal perspective as an elected local councillor. And the first time I stood, I did put my address on the nomination paper. And the second time, I chose to have it submitted but not on the paper for quite reasonable reasons that having people turn up at your doorstep is not always ideal. So it is a valid concern. As people have said, you're an elected representative, but having your address in the public domain may not be appropriate, and that's something that this covers appropriately without the amendment. So I think an understanding of that is important. The reference, I think, to the Gypsy Roma traveller community is perhaps an interesting one, or one that I hope there is scope, if somebody did not have a permanent address, that would be considered when a nomination was submitted, but I hope that's something that can be taken into account within the framing of this proposal. So I would like to speak against the amendment. Thank you.
Thank you, and thank you for your succinctness. The speech limit is 3 minutes, please.
Robin Lunn, Worcester 432. I too will be succinct, as the previous speakers really made the points, one of the points I wanted to make. I've to have been a councillor in the past. I stood for election in May, and I was always perfectly happy for my address to be on the ballot paper and for people to know this. Although it's very interesting, actually, nowadays, less and less candidates are confident about doing that. I know of the political party I stood for in Redditch, of the 8 candidates, I think only 2 of us were happy for our addresses to be put forward. However, I would like to think that elections for the General Synod are slightly different from that, actually, in that you'd like the electorate to actually contact the would-be candidates, send them emails. As Emma quite rightly said, people send letters far less nowadays, but you do want people to get in contact you, and if they have questions. So the more ways of people being able to contact online or by post, the better, really. So I just don't think this is appropriate, and perfectly happy for my address, and I would hope other people's to be on the ballot paper. Thank you.
Thank you. I might take another couple of speakers. Sir at the back there in the green shirt, and the lady there to your right in the green dress. Thank you. Yeah, I think I've had 2 speakers against, so if I could have anyone who wants to speak for the amendment. Debbie Buggs. And sir, if you would like to as well, thank you.
Debbie Buggs, London 353. We've had 2 speeches from people against Emma's amendment on the basis that they're happy to give their address. I'm pleased for you, but again, I'm not sure whether you live in a gated community or you've got other security. And I think not having to do this and not asking for it just levels the playing field. So, and as we know, people are most happy to get in touch with emails or even WhatsApp these days. So I don't see there is a great need for postal addresses to be made compulsory, or even to have an unlevel playing field in this respect. So I'm for Emma's amendment.
Thank you.
Chester 491. I agree with Debbie. What she just said about the necessity for this information to be asked for and published is perhaps something we don't need to do. I hear what Clive has got to say about ensuring that candidates are valid and that they do live within the constituency that they are supposed to be voted for, and so we can make that check without having to publish it to everybody else. So I don't see why we should continue to impose upon everyone the requirement that their address is public unless they choose to make it not public. And as one of the other gentlemen spoke, in an election, 8 people, 2 of them were the only ones who made theirs public, given the way things are in society. So maybe we can be at the forefront of this as a synod. Maybe we could be the ones who decide to make people's home addresses less in the public domain. Thank you.
I think I'd actually like to explore just a vote of closure on this one, actually. Just we have much to get through. I'm just proposing a vote of closure on debate on item 550. Those in favour? Those against? Thank you. That is carried. I invite Mrs. Gregory to respond to that debate, please. 3 minutes.
All I'd say is that we're talking about the address on the ballot paper or ballot portal. If you are happy for your address to be part of your campaign, part of your identity, that can go into your election address. Think about your electorate at the point of voting for you. Why do they need to see your address when they're going in to submit that vote? That doesn't make sense to me. So let's just remember that it's the address that would appear on that voting paper or voting portal.
Thank you, Mrs. Gregory. I'm now going to put item 550 to the vote. Those in favour, please show by indicating with a show of hands, and on Zoom, green tick. Those against? I think that is lost. No, I don't think it is lost. I can see there's enough people. So that amendment is lost.
I know you've got a much better view than I have, and a bottle of water. But it looked very close to me, and I just wondered whether we can move a count of the...
Mr. Margot, thank you very much.
Count of the whole
I think
synod.
I'm content from this vantage point that and we're not allowed to say clearly anymore, but there were certainly a lot more people who voted against than... well, we could have a counted vote if 25 members stand to desire it. So if 25 members would like a counted vote, and we'll count. Okay, we do have 25 members standing, so we will have a counted vote of the whole synod. This is a counted vote of the whole synod on item 550. Those present at Central Hall using the voting handsets and who wish to vote in favour should press 1. Those against should press 2, and those who wish to record an abstention should press 3. Those participating remotely should use the online voting platform and vote or register an abstention using the buttons on the screen.
The voting period is now open and will end in 1 minute. The voting period will end in 15 seconds. The voting period has now ended.
The voting was in favour 118, against 136, recorded abstentions 10, so the amendment was lost. I now call on Mr. Scowen to put item 513B, that the House of Clergy election rules be approved, to the vote. No, I don't need to vote, ask him to say anything else. I just put it to the vote. Oh, put it to move it. Yes, let's move it. Mr. Scowen, please do.
Getting a lot of opportunity to move this afternoon, Chair, which is, I'm sure, good for my health. Chair, I so move.
Thank you very much, in which case I would like to put that to the vote. Oh, I beg your pardon. It's open for debate, those who'd like to speak to it. I don't, in fact, see anybody standing, in which case we will now move to the vote. So those in favour of item 513B, that the House of Clergy Election Rules 2025 be approved. Those in favour, please show. All green ticks online. Those against, And Red Cross is online. That is carried. So we now move on to the House of Laity election rules 2025. That's item 514. And again, we have amendments on the order paper, so the procedure will be the same as it was under the previous two sets. The amendments grouped under each item number stand or fall together. So if I could call on Mr. Scowen to move item 514A, that the House of Laity election rules 2025 be considered, and again he may speak for no more than 10 minutes.
Thank you, Chair. And is that work? Yes. Thank you, Chair. For those with a wilting will to live, we are on the last two sets now, down to the last two sets of rules. And I've got very little to say about this one, because I've said it already in talking about the others. In elections to the House of Laity, there will be a facility on each diocese website for downloading and printing a nomination paper in order to help the laity in making nominations. The lay nomination forms will require candidates to state the parish or parishes on the electoral roll of which the candidate's name is entered, and that information will appear on the electronic voting form and paper ballot papers. And so I move that the House of Laity Election Rules 2025 be considered.
Thank you. That item is now open for debate. You, sir? I think as you're the only one standing, Debbie, you can have another go.
John Mason, Chester 280. And forgive me for hopefully not wasting everyone's time, but just a point of clarification on the prohibition of election material, which I realise actually also applies probably to the other two sets of rules. I just wanted to be clear that all that is being prohibited is the actual distribution of material at deanery synods and diocesan synods and so on, as if it looks like it's an official document, but that there is still the possibility of a candidate distributing material directly to the electors by virtue of them having received the addresses or the email addresses in the way that they are allowed to under Rule 13 here. I have to say I'm not terribly happy about that, because I think it means that those people who do that off their own bat, for instance, if they wanted to post them, would be doing it at their own expense, and that maybe disadvantages some people who don't feel that's something they can do. And to my mind, to distribute something at a deanery synod meeting in a separate way, which is clearly nothing to do with an official distribution, would just seem to be a very effective way of getting to the electorate who are actually going to elect them. Thank you.
Debbie Buggs, London 353. Thanks for letting me have a second go, Chair. I want to really pick up a little bit more on Aidan's point about the timetable and potential hitches with this. With at least 90 elections having to be counted within possibly 3 working days, depending on whether days 92 and 98 are on weekdays or weekends, that potentially means that there are at least 90 counts to be done. I'm not sure if members here availed themselves of the right to be present at the count and watch the screen on a Zoom call as it went through the numbers and picked the winners. But that could take 10 minutes per call, so we're looking at maybe 15 hours at least of Capita's time, which, if anything goes wrong, could put this timetable into under severe stress. So I would like confirmation at some point that Capita have done not just a reply to say, yes, we've got the capability of doing this, but we've got the capacity to do 90 in short succession. And I wonder if the Audit and Risk Committee should pick this up, because I know Capita don't always do as they've promised, and I think the Canterbury vacancy in C elections have reminded us that we do need to stress test things and do dry runs. Thank you very much.
Thank you. Pete Spears.
Pete Spears, Liverpool 154. Clive, you mentioned about electoral roll and parish in which you lived. You can, of course, be on more than one electoral roll. So I'm assuming what you're, so forgive me if I've not read this, you're saying where you live, the parish in which you live, which you may also be on the electoral roll of, and also the church that you worship at, which may be 4 or 5 miles away, where you're on the electoral roll. So could you just clarify whether you have to declare all the electoral rolls that you're on, or not? That's it.
Thank you. I'm just going to call one more speaker, I think.
I'm a little troubled about the rapidity, but the thing that concerns... Oh,
Could you have the name and number?
I do have both. The name is Debbie McIsaac, and it's Salisbury 402. I'm concerned about this timetable. Have you ever tried to get hold of anybody in the diocese on August the 15th? That's a very serious question, because you're expecting the staff to be around and the senior people to be around to sort out the inevitable, you know the word. I think maybe you should look at maybe having a slightly more elastic timetable to get things, and allow a week to sort out messes.
Okay, thank you. I don't see anybody else standing. So, Mr. Skern, would you like to respond to the debate, please?
Thank you, Chair. I confess I didn't hear perfectly what Mr. Mason said, but I think the point was about whether materials could be distributed at synods. Well, they mustn't be distributed under the authority of the presiding officer or anybody in the diocese. The important point here is that it has been known in the past for people to put the diocesan crest on things, or distribute things in a way that looks as if it's an official endorsement of a particular candidate. And that's what we're seeking to prevent. A deanery synod, or a diocesan synod for that matter, is a public meeting. I don't know how you would prevent people, even if they weren't currently members of that synod, from using that occasion to communicate with the electorate. And I don't think that's what we're seeking to restrict. It's the misuse of diocesan authority somehow to bolster someone's candidature that we're seeking to prevent. And certainly the practice in London, I don't know what other dioceses do, is that when we meet in July, June or July, prior to the election, that those current members of General Synod don't get to do anything official. So we're allowed to attend, but we don't get to report, for example, on this group of sessions, if the synod's after this group of the July group of sessions, and it has to be left to people who are no longer standing, who are demob happy and could say almost anything. Debbie and, well, the two Debbies, Debbie's Buggs and McIsaac, concern over the timetable. I mean, all I can tell you is that we have gone through this timetable in enormous detail with both those who've got to make it work in the diocese and those who've got to make it work at Civica. They have long notice now of the timetable, that they've got a year's notice of when the pinch points are going to be. They have assured us that they can do it. Civica also have the advantage of having run the elections 5 years ago, They know what was difficult for them then, and they think that what we have come up with here and the number of days provided over which the counts can be held does work. I mean, as you know, although obviously ballot papers, physical ballot papers, have to be fed into the computer, once that's been done, the actual count is achieved in seconds by the computer. And it just turns out a list of who's been elected and how many votes they've got and all the rest of it. So I suspect people may be thinking about the old way of doing it, which required a great deal more human input than necessarily is required with this system. Pete Spears, yes, it's electoral rolls, so if you're on 10 rolls, then they've all got to go on. Though anybody would quite manage to qualify for 10 rolls, I'm not sure. But yes, any church on whose roll you are present has to be recorded. It doesn't apply to the parish where you worship if you're not on the electoral roll, and the reason for that is that you then get into the difficulty about defining what constitutes worship. We all know the difficulty we have with regard to habitual worship when it comes to electoral roll qualification. It didn't seem to us to be reasonable to try to define that and to enforce that. What we were trying to do with this was to put in place things that were measurable. And indeed, when Emma Gregory moves her amendment in a minute, I'll say a bit more about that. But I do invite you now to decide to consider these rules.
Thank you, Mr. Skern. That 514A then is now to be put to the vote. Point of order, yes?
I think it's a point of order. It might be a point of clarification. Standing Order 19.2, I think. If with your permission, I'd like to respond to the question that Clive asked about how people could understand that, as meaning that I'm autistic. When I saw the rules about standing, I thought it did exactly mean that you couldn't tell anyone you were standing. I didn't understand that the official logo thing, that was news to me. I just learned that now. So I wanted to offer that as it does happen.
That isn't a point of order.
Is it not?
Let me just, no, I don't
I thought
think
it was clarification.
so. Let me just have a conversation with on those. It's not a point of order, but it's a very helpful statement nonetheless. Thank you very much. So could I now put item 514A to the vote? Those in favour, please show, and with a green tick on Zoom. Thank you. Those against, please show, red cross on Zoom. That item is carried. Now we now move on to the amendments. Item 544 lapsed, which means that item 551 doesn't need to be debated because it was consequential. So we now move on to item 552. If I can invite Mr. Sam Margrave to move that amendment. And Mr. Margrave, you have up to 5 minutes, but if you want less than that, I'd be very grateful.
As Sam Margrave, Coventry 295, as you know, Chair, it is considerably less than 5 minutes. I removed something very similar from clergy because my concerns don't really apply there about clergy as nominators or candidates because you can find them all in Crockford's. But Synod, this amendment protects those who want to participate without fear. Publishing candidates or the nominators' names and addresses deters involvement. I've got somebody I know in my diocese who I would love to stand, and they are a professional, and they often write about child safeguarding in court reports, so they couldn't publish their address. And I worry that we end up with a situation where there's an unconscious bias of who nominated who, or whose address is on there, and somebody didn't show their address, so they're not transparent enough. So I worry about we'll get to a who's got the best nominators situation. And I'm worried that also it's going to impact getting a more diverse group of people. There are others who simply don't want their names made public for political or personal reasons. And I just want to provoke safer participation, especially for those who just don't get involved in publishing their name publicly, especially for nominators. And it would reduce the burden on candidates as well, because you have to reassure people, oh, it's okay, your name going on there. And I've got plenty of names, because they all write to me. Some good, I know who's not going to put their name, and I know who is going to put their name. But I just want us to remove unnecessary exposure and to make it easier for people to be involved. And I really do hope that Emma will move her amendment, because they're very linked. And as I said, it's really important that we don't just have an opt-out, that we actually have a standard level playing field, and we don't have deference and potential unconscious bias. Thank you.
Thank you, Mr. Margrave. Mr. Scowen, would you like to respond, please, to Mr. Margrave's amendment?
Chair, we've already resolved the question about whether we require people to nominate. And if you do, which we're going to do, it is entirely reasonable that those people's names should appear on the ballot paper. I mean, some people will want to make a lot of who's chosen to nominate them and put it on their election address. They're free to do that. Others may not. But the electorate is entitled to know that somebody who is entitled to nominate them has done so. And the inclusion of the name on the ballot paper, it seems to me to be an absolute minimum for this process to make any sense at all. There is no requirement for the nominator's address to appear on the ballot paper. It is simply the name. And as we've already said several times, with regard to the candidate, they can opt out of having their address on the ballot paper at all if they so wish. So again, it's up to Synod what it wants to do, but we would make ourselves an outlier if we went for secret nomination. Again, coming back to what happens with secular elections, if, like me, you're sad enough to look at that notice in the polling station, you discover the names of the people. In that case, it's 10 people quite often that have to have their names there to satisfy the electors that somebody has been validly and properly nominated. And that's why we do it. I cannot see, particularly now we've decided that we want to continue with having nominators, I cannot see any reason why we would not have their names on the ballot paper. So I resist this amendment.
Thank you. Mr. Scowen, having resisted the amendment, in order for that amendment to be debated, we need to see 25 members standing. So if you would like to continue debate, please stand. We do not have 25 members standing, so that item lapses. If we could ask then, Mr. Margrave, if you'd like to move your amendment 553, and again, you have up to 3 minutes. Oh, 5 minutes, I beg your pardon.
Sam Margrave, Coventry 295. Synod, this amendment seeks to end a culture of deference in the Church and to remove the need for post-nominal letters from ballot papers. While the post-nominal letters actually have been put in to replace a previous provision, I'm very concerned about having them at all, and it's an opportunity to scrap it altogether. Candidates can still mention honours, titles or qualifications in their election address, but they have no place on the ballot paper itself. It will be said this just tidies up what's already there and it's optional. But let's dispense with this practice altogether. It's out of touch in 2025 with our culture. It's harmful too in the message it sends and the environment it creates, especially sending a message that those without letters aren't good enough, or creating imposter syndrome, or sort of influencing the electorate on the ballot paper. Research consistently shows that including designations, such as OBE, and I'm not picking on anybody in particular, or introduces unconscious bias, nudges voters towards candidates who appear more qualified or important. And how many letters do you allow? I had the ability at one point to put 19 letters after my name. And where do we draw the line? While it's optional, I'm worried that it'll actually become custom and practice, because if it's on the form to be able to put it on there, people are going to put it on there, and then you will create that deference between different candidates. And we want to have more diverse candidates who have no letters after their name. I just think a first and last name will do. You don't have to have post-nominals in other elections, so looking to local elections, as were discussed from the platform. And I've stood in plenty of elections and never had to put them on. I've even won some, which is hard to believe. So it's both unnecessary, and I'm fear about damage, and not creating a fair and equal playing field. Every word on the ballot paper should be neutral, so that we don't need post-nominals. I'd quite like slogans, but I see why we can't have them. We just need, as I said, first and last names. So let's uphold fairness, remove status signals, and ensure every candidate starts from an equal footing. If we want diversity, we must start with equity. I know it's not always natural to us, but let's vote for this, and let's modernise and place value in equality over who has letters after their name. Thank you.
Thank you very much, Mr. Margrave. Mr. Scowen. Oh, yes, you need to move. Please do.
I so move the amendment standing in my name.
Thank you very much indeed. Mr. Scowen, you have up to 5 minutes to respond, but I'm sure we'd be delighted if you didn't need all of that time.
Well, the Elections Review Group spent a surprising amount of time talking about post-nominal letters and which ones would be all right and which ones wouldn't. We came to the conclusion in the end that we should leave candidates free to put down what they want. This provision replaces something that used to say that people could indicate their preferred style. And this caused endless confusion. People really didn't know quite what they were supposed to say. So, and you know, those who've been fairies in the past may have a particular style they might want to use. So we decided to go for something that was clearer. And so what the provision actually is that people may include any title or post-nominal letters. So the effect of Sam's amendment would be that if you've got a knighthood or peerage, you can put that in, but not your OBE or the fact that you're a KC or anything of that sort. This seems to me to be unnecessarily prescriptive to prevent people doing this. If Sam's right, that it's not in touch with the culture, then it will not benefit the candidate if they do it. So people must judge what their personal style might be, and if their personal style doesn't involve post-nominal letters or involves using a preferred name which is different from their actual name on their birth certificate, they're free to do that. And so it's, I'm going to resist this amendment. I do not think that allowing this, which was really just intended as a clarification of what preferred style used to mean, I can't see that that's going to help anybody. So I resist the amendment.
Sorry, I just want to give a personal explanation because I think it's really important that a point was made there.
I'm not sure this is a point of order.
It's personal explanation under the standing orders. Something was said that I said, yes. And I think it's really important to make it very clear. When I was talking about culture, it is about the culture that we as a church want to present, whereas I believe that the electorate will see OBE and vote for that person instead of voting for an 18-year-old who's never been on a synod. Thank you.
Okay. Well, I think we'll let the debate continue if Synod desires that. So if you want to continue the debate on this amendment, I need to see 25 members standing. I think we do. Yep. We do have 25 members standing, so the debate is open on item 553. You, sir? And you, sir, right up there in the gods. Yes, thank you.
Andrew Dotchin, 208 St Edmundsbury in Ipswich. Thank you, Chair, and I am a fairy by deed of the late, much-loved Geoffrey Tattersall, who proclaimed me the Sweetie Fairy of Synod. I'm also a member of the Third Order of the Society of St Francis, and I will sometimes put the letters TSSF after my name. There are members of our community in the House of Bishops, in the House of Clergy, and in the House of Laity. Why should only one group not be able to say who they are? When it comes to public recognition, I hope this would give voters an indication of where the community trusts them. If the community has already supported someone by them being given a public award, it may help us in finding our vote. I admit I'm a cleric, so it's not my vote in the House of Laity, but if we're going to make the distinction here for laity, we should make it for all three houses.
Thank you. The speech limit is 3 minutes, but again, succinctness will be valued.
Thank you, Chair. Durham, 107, Mark Miller, BSc, SSC. It stands for Bronze Swimming Certificate and Silver Swimming Certificate. Synod, we do not need this. I absolutely agree with Andrew. This should have been for all three houses. But we don't need this. I completely agree with Sam's amendment. I work in the most deprived parish in my diocese. I desperately want to see a diversity of presence here in Synod. And I have heard it said that two of the chief dangers facing the Church of England are educationalism and elitism. We really don't need to have post-nominal letters after our name. And I ask that you would support Sam's amendment. Thank you.
Thank you very much. I'd like a person who'd like to speak for the amendment. Yes, and against the amendment. Yes, sir.
Ros Clark, Lichfield 336, and a member of the House of Laity. So this is my part of the proceedings. My brothers and sisters, believers in our glorious Lord Jesus Christ, must not show favoritism. Suppose a man comes into your meeting wearing a gold ring and fine clothes, and a poor man in filthy old clothes also comes in. If you show special attention to the man wearing fine clothes and say, here's a good seat for you, but say to the poor man, you stand there or sit on the floor by my feet, have you not discriminated among yourselves and become judges with evil thoughts? There is a place for nominees, for candidates to describe who they are, to find their tribe, to find their vote, and that is on their election address. On the ballot paper, there should be nothing but a name. Thank you.
Chester 278. FBSL, which stands for former Beaver Scout leader. I've not been a fairy, I've not been a grumpy dwarf, but I have been a jolly milkmaid. Ask me later if you want to know more. I have 3 O-levels, 6 GCSEs, and an ONC in Mechanical and Production Engineering to my name. I did do 24 years working in a warehouse. I honestly believe I was elected because God wanted me to be here, because I put in an election address, and I wrote an election address, which was a draft, sent it to a friend who helped me do a really nice singing, all dancing one. Put in my address, the votes came in. I wasn't on Deanery Synod, I wasn't on Diocesan Synod. I'll tell you how. I put in for it another time. I haven't got the time now, I've only got 2 minutes. Long story short, I was gobsmacked when I was elected. I was even more gobsmacked when I looked at my fellow candidates and their election addresses, and I looked at mine. Now, I swear I put my all singing, all dancing one. It was my draft one. I believe I was elected because God wants me here. And Sam, I see where you're coming from, but I honestly believe that if God wants you here, you'll be here. And it doesn't matter whether you're a doctor or a man with 3 O-levels from Chester. Thank you.
I think I'm just going to pursue a motion for closure on this amendment. This is a vote for closure on Amendment 553. Those in favour of closure? Thank you. Those against? Thank you. So in which case I think we now put that to the vote. Oh, I beg your pardon. And please do respond to the debate. And you've got up to 3 minutes.
I'm not going to get an opportunity again, because obviously I completed the hurdle of amendments, but I wanted to thank Clive for his responses and to thank all of the panel for their incredibly hard work on bringing all of this forward. And just to respond to say that the reason I focused on the House of Laity is, we could say it was a pilot and look at it that way, but I will be asking for a count of the whole synod if possible, just because I think it's a really important issue, personally, about the culture of the church and about the very nature of ballot papers. And I agree with the issue around sirs or ladies or etc. I didn't consider that. If I had been better equipped, I probably would have got rid of that too. But I would ask you to just get rid of post-nominals because I just don't think they're appropriate for the world we live in, and they don't have them in local elections, and I don't think we need them in the church fit for the 21st or 22nd century. Thank you.
Thank you, Mr. Margrave. That request for a counted vote of the Synod has my consent. So we're going to now have a counted vote of the whole Synod on item 553. Those present at Central Hall using the voting handsets and who wish to vote in favour should press 1. Those against should press 2. Those who wish to record an abstention should press 3. Those participating remotely should use the online voting platform and vote or register an abstention using the buttons on the screen.
The voting period is now open and will end in 1 minute. The voting period will end in 15 seconds. The voting period has now ended.
Thank you. Those in favour, 161. Those against, 89. Recorded abstentions, 22. So the amendment was carried. We now move on to item 554. Could I invite Mrs. Gregory to propose her Motion standing at 554.
Emma Joy.
You have up to 5 minutes, but of course, again, very grateful if it was shorter than that.
It will be Emma Joy Gregory, 247, Bath and Wells. I've already given my speech on this, but just to add a couple of points, we're now looking at whether it makes sense to have a layperson's address on the ballot paper at the point of voting. I appreciate there's an opt-out process, but to me, just picturing that, where half the candidates have got their address and the other candidates have not got their address for reasons that aren't clear, that to me seems that would do more harm than good. I really don't understand why it makes sense to have a lay volunteer's address on the voting portal at the point of voting. Said my piece. Thank you.
Thank you very much.
I move my amendment.
Thank you very much, Mr. Scowen. If you could respond again succinctly to Mrs. Gregory's amendment.
I don't think there's much more I can say than I said before, but it is to do, I think, with giving people maximum information that can reasonably be given, helps those who want to base their voting on the geography of the diocese, and given the provision to opt out, I do not see that there is anything to be lost by keeping this requirement in. It's also worth noting that not all of us have distinctive names. There are a lot of people who have the same name as other people, and you may well get two people with exactly the same name on the ballot paper. Now they're not allowed even post-nominals. We've got to have some way of distinguishing them, and their address clearly would do that where they've given it. So again, I resist this and leave it to Synod to decide whether they want to debate it.
Thank you, Mr. Skern. In which case we need to see 25 people standing if we're going to we're going to debate this. We do have 25 standing, so that item is now open for debate. Lady over there in the spotty dress, thank you. Sean, would you like to come down? A speech limit, I think, needs to be 2 minutes, please.
Claire Williams, 372 Norwich. I'll try and be very brief. Just to respond to the point of geography, I think from my own personal experience, my address would identify me as living in a really rural area in our large diocese and having a particular type of experience. I actually work 25 miles away from where I live and have a very different experience in my role working for a cathedral. So I wouldn't want my address to be a limiting factor in people's understanding of my experience and my contribution to this synod. Thank you.
Sean Doherty, University St TEIs 450. Thank you, Chair. I think it's, as Clive said, it's important for electors to have the transparency and to have the confidence to know that somebody's been validly nominated, that they live in the right place and so on. There's no reason that information can't be made available to them in other respects. So it could be available on request, or it could be stored and made available somewhere else if that's considered to be desirable. I completely agree with Emma's point, though, that it's at the point of making the choice. It's in that kind of window in the election portal that I think it's significant, particularly not so much that, I mean, it could be about where they live that could confer some advantage or disadvantage, but I think it's also the fact that some people's addresses at that point will not be supplied. Seems to me that's quite likely to place them at a disadvantage, because electors may think, oh, why has that person not given their address? Whereas on the other hand, it's far more likely it's for good reasons rather than bad. Thank you.
Very much. I'm going to take two more speakers, and you, sir, in the blue shirt, you, sir, in the green shirt at the back. Again, 2 minutes maximum, please.
I'll take 2 minutes. Chris Angus, Carlisle 265. Clive made a really quite important point about being able to differentiate between people. I'm in a parish
which has really quite a small population. Until very recently, when one died, we had 2 Margaret Rutherfords. So I think at the moment, the address would be our only way on the ballot paper of differentiating them. So if we decide that we get rid of the address, then I think we do need to determine how we actually handle that problem.
Robert Perry, 426 Truro. I'm going to say what I would have said had I spoken on the previous time this came up. I regard myself as holding a public office by virtue of membership of this synod. I'm responsible to the people of the Diocese of Truro who place their trust in me, and I feel it's entirely appropriate that if they want to get in contact with me, they know where they can find me. I would just say, though, that certainly before this group of sessions and before the previous one, I was lobbied quite extensively on the financial support for diocese papers that we dealt with on Friday or Saturday. And every one of those contacts was by email. I haven't had a letter from anybody in a very long time. So perhaps we were arguing over nothing. But in any event, I will vote against this proposal.
Thank you. Can I ask Mrs. Gregory to respond to the debate, please? Oh, I beg your pardon. No, I need a vote of closure, sorry, before I do that. Could I propose a vote of closure on item 554, please? Those in favour? Those against? Thank you. Mrs. Gregory, would you like to respond?
Emma Joy Gregory, 247 Bath and Wells. Not a lot to say other than that I'm not massively convinced by the point about 2 people having the same name. That to me is not strong enough to argue against publishing lay people's addresses.
Thank you. I now need then to put item 554 to the vote. Those in favour, please show, and those against, those in favour, please show green ticks on Zoom. Those against? That's quite close. I think I'm going to need a vote on the electronic devices, I'm afraid. So if we could move to that. So I'm now going to have a counted vote of the whole synod on item 554. Those present at Central Hall using the voting handsets and who wish to vote in favour should press 1. Those against should press 2. And those who wish to record an abstention should press 3. Those participating remotely should use the online voting platform and vote or register an abstention using the buttons on the screen.
The voting period is now open and will end in 1 minute. The voting period will end in 15 seconds. The voting period has now ended.
Those in favour, 118. Those against, 134. Recorded abstentions, 11. The amendment was lost. Before we proceed further, I should remind the Synod that we are due to complete the business before us in a few minutes. Understanding Order 15.6, I may, with the general consent of the Synod, extend this sitting by not more than 15 minutes. In order that we may complete this business, I propose an extension of the sitting of not more than 15 minutes. Does the Synod give its general consent to that? I think that is sufficient to say yes, thank you very much. Well, those against, you should indicate yes. No, I think the ayes have it, so that's good. Thank you very much. We move on to item 555. Again, Mrs. Gregory, would you like to speak to this amendment?
Emma Joy Gregory, Bath and Wells 247. Sorry to intrude on your time, it's nearly dinner time, but actually I'm not sorry, because this is important. This amendment seeks to remove the requirement for a member of the House of Laity to have the name of the parish in which they are registered on the electoral roll listed on the voting paper or voting portal. At first glance, this might seem like a harmless idea, just a bit of extra information to help electors make their choice. I can see the principle of transparency here. However, transparency is all well and good, but sometimes it is the case that only some of the information is more harmful than the alternative, as I've been trying to argue. This is a good moment to reflect on the kind of people we want to serve on General Synod and the barriers that may be preventing them from doing so. Let's think about candidates from ethnic minority backgrounds, candidates who are young, candidates who are good public speakers, candidates who bring expertise in areas that we need, finance, safeguarding, church buildings, candidates who are working class, candidates who are deeply committed to Jesus Christ and to serving on Synod. None of that has anything to do with the parish from which they come. Now, let's flip the perspective. Imagine an elector, perhaps not the most engaged member of Deanery Synod, who receives the voting email, skims the list, and just maybe doesn't read all the election addresses in detail. What information do they see at a glance? Alongside a few other basic things, like their address, the name of the candidate's parish. And what might they do with that information? They might make a decision not on the layperson, but on what they know, or what they think they know about the parish. Maybe that church has a vicar who misbehaves on Twitter or whatever it's called. Maybe the church is in a part of town they don't like. Maybe the church has bells that annoy the neighbours. Maybe it has a notice board with a missed apostrophe. Maybe the church is known for a particular theological stance on a hot topic issue like LLF, and so the vote is cast on the reputation of the church. Heaven forbid. We already know that Synod has deeply entrenched churchmanship divides, and these can erode the love and respect that we are called to show one another. Including the parish's name next to a candidate's name risks deepening these divides. It invites assumptions, it invites bias, and it distracts from what truly matters, the person, their calling, and the capacity to serve. This amendment is about fairness. It's about removing an unnecessary detail that could too easily become a stumbling block. So please vote for my amendment, which I move now.
Thank you, Mrs. Gregory. Mr. Skern, if you'd like to respond, please, to Mrs. Gregory's amendment.
Yes, thank you, Chair. Although before I do, for the three people who haven't been following their electronic devices, England won the test match by 22 runs. When we consulted at the beginning of our work, we got a lot of representations from people who wanted to be deeply prescriptive about what went on an election address. You have to state this and that and the other thing. And we resisted that in favour of information which is entirely neutral and eminently verifiable. And we took the view that electoral roll membership, because it is the fundamental qualification for being able to stand for Synod in the first place, that was something that we could legitimately require, not on the election address, but on the ballot paper, so that people could see that somebody was on electoral roll and that it was a church that really existed. Now, what people make of the information they're given there on the election address, or whether they read an election address, these are not matters that we can legislate for. All we're simply seeking to do is to give that basic information about the basis upon which someone is qualified to stand for General Synod. So I want to defend the position that we arrived at. As I say, it wasn't done on a whim. It was done, as I say, in the light of a number of representations that we received, most of which we decided not to follow. But there were some points that we felt that were legitimate, and this was one of them. I also point out that the clergy rules do require clergy candidates to state the ecclesiastical office that they hold. No attempt was made to amend that out of those rules, and so one might think it a little inconsistent that we require the clergy to disclose that and not the laity. Thank you.
So I think, Mr. Scone, you are resisting that amendment. Oops, a daisy. Okay, so Mr. Scone is resisting that amendment. If we're going to just carry on debating it, we need to see 25 people standing, please. Yes, we do have 25 people standing, so that item number 555 is now open to debate. Lady over there in the flowery dress, Charlie Bell. This is definitely a 2-minute speech limit, please.
Jill Ball, 269 Chelmsford. Very tempted to style myself her Lady Jill of Essex in it. I should like to speak against this proposed amendment. I think the inclusion of somebody's parish is a really, really good idea. I have become something of a nerd when it comes to reading electoral statements and information about candidates. And I think the more information you can get about somebody, the better. I love reading, especially for lay people, about their backgrounds, their interests, all the things that they do, their qualifications. But if one was a deanery synod member, an elector, and didn't have time for that, giving somebody's parish at least gives a start. It gives a little more information, and it will give a better informed electorate. I think that's really, really important. Also, importantly, we've spoken a great deal about the need for diversity in people who are standing for synod, and this is part of that. I am interminably nosy about people's churches. I think it's great to find out, is this a small church, a large church, an urban church, a rural parish? Do they have a predominantly younger or older congregation? I can understand the points that Emma has made, especially about not being in agreement with the whole of your parish. That's sometimes where I find myself, sorry to my church leadership. But that is what the clarity and detail on your electoral statement is for. Yes, you can declare your position there on hot topic issues and on apostrophes on notice boards. So I feel that the inclusion of your parish is essential. So please vote against this amendment. Thank you very much.
Charlie Batchick-Bell, Southwark 221, which reminds me that I am a gay monosexual who is a husband and a priest or father. I want to just raise a question about the language that was used to describe the amendment, which was that the parish was quoted, quote, an unnecessary detail, unquote, which worries me as a statement in the context of elections to what is a synodal body, bishops being in synod. I think the parish from which we come is the very least of the things that we might describe as unnecessary details. I do think that there's a question of transparency, which Clive has spoken about, but I actually think this is primarily an ecclesiological or a theological problem of not including the parish. Because each of us here is situated within a parish community. Our place within this synod, in many ways, springs from the Christianity, or rather our Christian perspective, that comes from a situated life. And our situated life is in a particular place, a particular Christian community. I have a much higher opinion, it seems, of lay people than some in this chamber to make sensible decisions about these kinds of things. So I would really argue and urge us to remember that we do have a situation as Christians, and we bring that situation into Synod. And it's very important that those who know who their representatives will be able to think about what that situation is as part of their thinking to elect those into this room. So I urge you to reject this amendment.
Thank you. I'm going to call a couple of speakers who are in favour of the amendment. Yep. Anybody else in favour? Yep. Jake.
Rebecca Chapman, 414 Southwark. Thank you for calling me Chair. Synod, I spent my adult life in all shapes and sizes of Church of England churches. I worked at a central London mega church as a graduate. I've worshipped in small urban London churches with Pentecostal vibes, and I have adored the numinous nature of my recent decade in an Anglo-Catholic inclusive parish, Charlie's parish in fact, where my children have sung in the choir. And I've just moved house, not just the result of our C&C debate last session, I promise. And I now attend the local parish church next to my new home. It's low church evangelical and a huge culture shock for my children. As the elections approach next summer, I'll be prayerfully considering whether to stand again, but it's possible people might make assumptions about what I think, what I believe, based on the parish I attend. Perhaps they'll be voting in haste, but I would love to encourage my electorate to base their vote on my actual election statement, where I can tell them more about my parish and why I picked it, which for me is about geography, which they'll have from my address since the previous amendment fell. We might each have many different reasons for we worship, logistics like travel, musical involvement, or mission. But they're very, very different for each of us because we're individuals. Please consider supporting this amendment and discourage anyone from accidentally making assumptions about each other, in this instance based on the parish's name alone, where they might assume things like the theology of it or its vicar, and instead focus on the candidate's commitment to them as the electorate and the reasons that they set out for standing. Thank you.
So Jacob Vince, Chichester 292. I've said for General Synod, this is my fourth term. All three of the previous terms were all from the same address and the same parish. But I've actually, when I lost my lost my wife and then remarried, I ended up moving, and I then moved twice in the same period, so I would have been in 3 different parishes. So I put a parish down, which I was, and of course the last time it was in COVID, so that was even more difficult because I was making an adjustment. Actually putting the parish down wouldn't have necessarily given any help to anyone, and then I would have had to explain too much more within my address itself. So people do change within the diocese, changing address, things like that, which will affect the change of parish, and that it just happens to be what lands when it does.
I'd like to explore a vote for closure, motion for closure on this item. Those in favour? Thank you. Those against? Thank you. That's carried. So, Emma, would you like to respond, please, to debate?
Nothing more to say. Enjoy your dinner.
Thank you. Thank you, Mrs. Gregory. So I'm going to put that motion. Point of order.
Could we have a count of the whole synod? I just think it's important to...
Thank you, Mr. Mulgrave. I think that does have my consent. I suspect that will be close. So yes, we will. This is a counted vote of the whole synod on item 555. Those present at Central Hall using the voting handsets and who wish to vote in favour should press 1. Those against should press 2. Those who wish to record an abstention should press 3. Those participating remotely should use the online voting platform and vote or register an abstention using the buttons on the screen.
The voting period is now open and will end in 1 minute. The voting period will end in 15 seconds. The voting period has now ended.
That was in favour 58, against 196, recorded abstentions 5. The amendment was lost. And I ask Mr. Scowen to move item 514B.
Chair, I think I ought just to respond to Chantal Noppen's non-point of order that was very helpful. It was very helpful, and I expect what you heard somebody's noted, but if you'd like to write in with that point and anything else you've noticed that you think might be challenging to, well, almost anything else that you've noticed that you think would be difficult for neurodiverse people to follow, that will help us to improve the help us for the future, but also particularly the guidance that's going to be drawn up in the autumn. So please do let us know. Apart from that, Chair, I'm just going to move that these rules be approved.
Thank you, Mr. Scowen. Bearing in mind we are now voting on 514B. Do we have to open to a debate? We do. Oh, I beg your pardon. Debate. Oh, well, I think we should have a debate. Anyone like... Up there. No, we're exercising the sweet taste of democracy, friends. Don't, but only for 2 minutes.
Dave Ashton, 324, Leeds. I'm going to vote for this, but there's an inconsistency, and both of them affect me. I was proud to accept an honour from the King, but I don't use it for an advantage. I know what it was for, my friends know what it was for, but I don't use it as an advantage. But also, I'm 84. I'm in good health. I garden a lot. I walk. And I better say this, else I shall be in trouble when I get home. My wife is 12 years younger than me, and she keeps me young. I shall be married 50 years in October. No, I've only got 2 minutes. But that has to go down on my ballot book, that I am 80. And people who don't know me don't know the state of my health. And it can be seen by some people, 84, is he past it? No, I'm not. And I enjoy doing what I do. My daughter, who's a medical, says, use it or lose it. And I try to keep using it. There is an inconsistency that we've done here, but I will vote for it because I hope that if people ask me to stand, I've got the gift to stand, and if they think so, they'll elect me again. It's up to the electorate.
Thank you. I didn't see anybody else standing, so Mr. Scowen, a very brief response, and then we can vote on this item.
Just to say to the grandfather of the house, I think he was described as earlier, congratulations on your long marriage and your age. There is no... Well, I doubt if I'll get there, but the only reason there's an inconsistency is because you voted a few moments ago to disallow post-nominals. That was Synod's decision, and probably not the first time Synod's taken a decision that's not wholly consistent with other things. But anyhow, let's get this over the line and vote for it, please.
So I put item 514B, that the House of Laity election rules 2025 as amended by item 553 to the vote. Those in favour? Thank you. And green ticks on Zoom. Those against? Red crosses on Zoom. That is carried. Mr. Scone, would you like to come back and do the last item for us? 515.
This really is the last item. There are no amendments. I need just to, well, I've got to, there's on a bit of paper now because we've been here so long that my computer's died. There are no substantial amendments involved with this set of rules. There are tiny changes reflecting changes in other rules and to the information required on nominations. Otherwise, it's entirely concerned with substituting the name of the new election rules for those of the 2020 rules. And I beg to move that the single transferable vote rules 2025 be approved.
Thank you, Mr. Scone. That is actually open for debate, although I was inclined to give you only about 1 minute if anyone really wants to speak to it. I see no one wishing to speak, therefore we are going to put item 515, that the single transferable vote rules 2025 be approved, to the vote. Those in favour? Thank you. Those against? That item is carried. That concludes this item of business. We now move on to worship.